Kern Government Television, welcome to this week's Kern County Board of Supervisors meeting, originating from the County Administrative Center located at 1115 Truxtun Avenue, Bakersfield, California. Kern County's vision is to create and maintain a customer-centered county government designed to garner the confidence, support, and trust of the people we serve. Today's Kern County Board of Supervisors meeting will convene momentarily.
I'd like to call this morning's meeting to order, special meeting. Board to reconvene. First item is the roll call, please.
Supervisor Gleason.
Here.
Supervisor Scrivener.
Here.
Supervisor Maggard.
Good morning.
Supervisor Couch.
Here.
Supervisor Perez.
Here.
Next item is the salute to the flag. It will be led this morning by our Chief Administrative Officer, John Nylon. And please remain standing at the conclusion of that for a moment of prayer, silence, or meditation, whichever you prefer. Thank you.
Please join me in saluting the flag of these United States of America. Salute, pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item 1 is public presentations. This portion of the meeting is reserved for persons to address the board on any matter that is not on the agenda but is under the jurisdiction of the board. Is there anyone here that would like to make a public presentation? Please step to the microphone, give us your name, and proceed.
David Fluhart from Havelock, District 1. Good morning, Honorable Chairman Couch, Supervisors, Administration, staff. And I'm here today representing the CFD Think Tank Club and representing an organization with mutual goals of Kern County. We would like to take this time at this podium today to recognize the board, administration, staff, and their tireless dedication to the safety and happiness of Kern County. To be sure, we have had a difficult couple of years, from the KMC stumble to the finalization of the IT building to the construction of the community hammer. We have overcome great obstacles. Mr. Judd has taken his victory lap to roaring fanfare. The IT building sits across the shiny beacon on the hill, which is Bakersfield College, and the new prison, well, I'm sure it's in good hands. And with the dry drought and fracking fight, difficulty and challenge awaits the board with every sunrise. And in these difficult times, the CFD Think Tank Club has empathy for the board's difficulties in balancing our future. And so we'd like to express our appreciation to your participation. Thank you. Made a cute little certificate here, and on top of it, I know it's not quite a proper plaque, but I've got a little memento for you guys. It's a simple little toy, but the naysayers and critics will think it's a joke, but no, I know you guys can figure out the problems from where you sit. I do appreciate your guys' hard effort, and I don't know exactly the finer details of everything here today, but I trust in you guys because you guys are good people and you put a lot of thought into what you're doing and the hard work that you and your staff and your administrators combine to create. Thank you very much.
Thank you. Are there any other public presentations? Seeing none, we'll go to item 2, which is board member announcements or reports.
Mr. Chairman.
Supervisor Gleason? Yes.
First thing I'd like to do is congratulate Roscoe on a great football game. I went to the Shafter pep rally and last Friday morning, and it was just a class act. I can see why it's such a great rivalry. I'm so proud of Shafter and Roscoe, and thankful to be able to participate in that. Second thing is Veterans Day. Coming up this Wednesday, a great opportunity for Kern County to stand tall and take a moment to thank your vets. Thank you very much.
Thank you. That brings us to item 3, and I'd like to start by welcoming you all again to the special meeting of the Board of Supervisors. There's someone here Mr. Lopez making his way to the microphone. If there's anyone here that would like to hear this item in Spanish, Mr. Lopez is here to translate. Mr. Lopez.
Si hay alguien aquí presente que quiere escuchar la Junta en español, yo, Fernando López, estoy aquí para traducirles.
Are you directing them as well to the back of the room?
En la mesa de atrás hay unos audífonos. Si necesitan audífonos para escuchar lo que está pasando, vayan para allá ahorita.
Thank you. Is there anyone here who would like to have that, either here or in the rotunda, that would like to take advantage of these services?
I've already checked out there. There's already a person with them here in front.
Okay, thank you. We understand that you may not be regular attenders of our meetings. In fact, some of you may be here today from outside Kern County. We want all of you to enjoy your day with us and to be as comfortable as you possibly can. If you have questions about, for example, where a restroom is or where you can get a drink of water or where the cafe is, I would direct you to our deputies that are stationed in the back of the room and also in the rotunda. Let me explain a little bit about how today's meeting will proceed. First of all, our staff will make a presentation that we expect to go about 45 minutes to an hour. The applicant will then make a far shorter presentation, probably just a few minutes, and then I'll open the public hearing and we'll receive testimony and comments. Those in opposition to the staff's recommendation will be first. When everyone in opposition has spoken, we'll have those in support speak and give us their comments and testimony. After everyone has had a chance to speak, whether they are in opposition or support, I'll close the public hearing, and we'll probably have staff respond to some of the comments that were made after the close of the public hearing, and at that point, we'll return it to the board for questions, comments, and possible action. You'll notice that the front row is open. I'm going to encourage you to come down and sit there while you wait to speak. That way, we don't have to wait for you to get out from the aisle and come down the aisle here also, and we think it'll just make the meeting move along much quicker. I'll try to let you know throughout the meeting when there are seats open in the front row. So if you're out in the rotunda, you'll know that you have a chance to come down and get into the front row so you can speak. Now, how long are we going to speak? Can I ask for a show of hands here in the chambers and ask the deputies to make a quick count for those in the rotunda? How many of you are here to speak on this? Let's start with opposition. How many of you are here to speak in opposition? I'm going to say that's roughly 10, 15 people on the right side over there. Could I get one of the deputies to let us know how many are out in the rotunda? Approximate. Approximately 20. Okay, so around 30 to 35 people. I think the Planning Commission, they had a 5-minute time limit, so we'll impose that 5-minute time limit here as well. And we ask that you do your best to stick to that. We're also going to have a break for lunch at around noon. No, that's good. We're going to have a break for lunch at around noon. And depending on where we are in comments, we could get there a little sooner, or we could get there a bit after. I expect that will last about an hour, but we will let you know exactly what time we'll be back and we will be reconvening. Is there anything I missed that people might want to know? Madam Counsel?
Good morning, Chairman Couch and members of the board. Chairman Couch, did you want to ask how many people wanted to speak in favor?
No, I think we have to give them the same amount of time.
Okay.
Okay, so this takes us to, we are now at item 3. This is the time to consider agenda item number 3, which is a request from the Kern County Planning and Community Development Department, Western States Petroleum Association, California Independent Producers Association, and Independent Oil Producers Association to revise the Kern County zoning ordinance to, 1, amend various portions of Title 19 of the zoning ordinance to implement a new land use approval process for oil and gas exploration, extraction, operations, and production activities. These proposed amendments include implementing new site development standards and review processes, revising several county zoning ordinance chapters to make them consistent with the proposed requirements of Chapter 19.98. The specific numbers of the chapters proposed to be revised are identified in today's written agenda. I believe there are copies of the written agenda at the back of the room as well. 2, to consider a final environmental impact report on 2.3 million acres located countywide that includes, without limitation, proposed findings of fact, proposed statements of overriding considerations, and a proposed mitigation monitoring and reporting program. Several sites within the project area are listed by Cal EPA on the Cortese list as identified in the final environmental impact report. I think that concludes my opening comments. I'm going to turn it over to Director Oviatt for her staff report.
Good morning. Thank you, Chairman Couch, members of the board. I'm here today with the county team. Sitting to my right is Chris Mink, supervising planner, and in the chamber is staff planner Sean Beeler, Craig Murphy, a division chief, and Scott Denny. We also have on the team Jennifer Hernandez, who is outside counsel for the county from Holland and Knight, sitting next to Ms. Goldner. Proposed project consists of revisions to Title 19 of the Kern County zoning ordinance with emphasis on Chapter 19.98, which is oil and gas production, and related sections of the zoning ordinance to update procedures, implementation standards, conditions for future oil and gas exploration, development, and production activities in unincorporated Kern County. As noted, it's presented with a project-level environmental impact report for consideration that will be used for compliance with the California Environmental Quality Act, CEQA, by the state agency with authority over oil and gas permitting, the California Department of Conservation, Division of Oil, Gas, and Geothermal Resources, which during this hearing we will refer to as DOGGR, as well as other state agencies. For the benefit of your board, I note that the state constitution mandates that underground activities for oil and gas exploration and production are reserved for permitting by the state. So DOGGR permits the underground oil and gas activities in operation, and only the Surface Land Use Authority and compliance with CEQA is under your authority and is presented for your consideration. This project was directed by your board in 2013 with the support of the state and DOGGR. And the board directed the planning department that the project be fully funded by the oil industry if it was to move forward, and that they be included for technical assistance as applicants. The board further directed that a proposal to address conflicts between surface owners, specifically in agricultural areas, and those conflicts between surface owners and mineral owners be provided as well. The industry participated through their associations, the Western State Petroleum Association, WISPA, the California Independent Petroleum Association, SIPA, and the Independent Oil Producers Agency, IOPA. The industry seeks a local streamlined permit to provide for compliance with CEQA for all state agencies. And your board referred this also to address questions and concerns that have been raised by the public and to bring forward new standards and appropriate mitigation for impacts to the environment. Project covers the entire 2.3 million acres of the valley portion of Kern County. This project, which we have a boundary map up, includes both the established oil field areas and areas that are emerging. For purposes of permit authority, it only covers the unincorporated areas of private land and not the cities. So to recap, what is in this local permitting program elements? First, there are amendments to the Kern County zoning ordinance text, which implements a new local permit and process in the planning department. There is a final environmental impact report and mitigation monitoring program that will be instituted through that local permit. We have brought forward a new GIS gateway and electronic permit system we are proposing to your board to streamline this and also to provide the public with the access to the information about what is being permitted where. It will require new staffing, new fees, and we are also proposing new additional policy-level programs, such as a small producers assistance program and a legacy program. So those are the elements, and as we work through this presentation, I will be clear what things your board has been noticed to take action on today, and what things are for a future hearing. So just to recap the current permitting, the current provisions in Title 19 of the Kern County Zoning Ordinance are primarily contained again in this one chapter, oil and gas production. And under those rules, oil and gas exploration and production in Kern County requires no permit from the county, with the exception of requests for oil drilling in residential R1 designated areas. So this is your traditional tract where you have 6,000 or 7,000 square foot lots that do not have established drilling islands in the tract. In addition, there are some things in the oil field that do require a building permit, but there is a limited list of those requirements in the building code. If there is no drilling island in a residential tract, then a conditional use permit is required. But as we note in the staff report, only 2 conditional use permits have ever been processed by the planning department. They were both done in 1986. And yet there are over 58,000 active wells and over 11,000 idle wells in Kern County. So we've done 2 conditional use permits in residential areas in those 58,000 active wells and 11,000 idle wells. All of those wells have been permitted, managed, monitored for compliance directly by Dogger. Once again, there was no permit required from your board, and this has been the established relationship with oil and gas for the last 116 years in Kern County. And the original intention was that the state of California, the Water Board, Fish and Wildlife, Air Board, all of these agencies would be regulating, and they do, all of the activities in the oil fields. Development standards were established, but they are very limited. So while we don't require a permit, we did require some minimal standards. Those are shown on page 5 through 7, but compliance with them did not require that they come to the county for a permit. So I want to touch on other agencies as well. So currently, as we note, underground and above ground construction and operation of wells is subject to Dogger. This includes permitting, drilling, operating, maintaining, plugging, abandonment, all of the accessory tanks and other sorts of things that go along, pipelines that go along with oil production. In addition, the Dogger Oil and Gas Supervisor may establish field rules for any oil and gas pool or zone in a field where there's sufficient geologic and engineering data from previous drilling operations. So these field rules, these very specific area rules, supplement applicable state regulatory and statutory requirements. Each field rule is specific to a field, and in many cases specific to pools of underground locations within a field. So this is the standard of current regulations. Under CEQA, the California Environmental Quality Act, the lead agency is the public agency which has the principal responsibility for carrying out or approving a project which may have a significant effect on the environment. With respect to this final environmental impact report, the county has assumed lead agency status because we are instituting a new permit, which will be a requirement of all new drilling going forward if you approve this and once the zoning ordinance becomes effective. So no longer will there only be a Dogger permit. There will be 2 permits, a Dogger permit and a Kern County permit. And even if they get a Dogger permit, without the Kern County permit, they cannot commence drilling or other activities. The CAR was prepared as a project-level document that could then be used by responsible agencies to comply with CEQA in conjunction with the issuance of all the permits that other agencies need. That's why they call it a responsible agency. So the Department of Fish and Wildlife is a responsible agency. The Central Valley Water Board, and there is a list on page 3 of your staff report along with the full discussion of the roles of responsible agencies in implementing CEQA. I remind your board that this is something that you have done before. We have one of the largest solar projects in the world in Kern County, with the other half being in LA County. And you acted as the lead agency for that solar project in District 2, and LA County acted as a responsible agency. And that is an example of the very same process that we are instituting here, that we are proposing to your board today. So what is the proposal? So the size and scope of permitting in Kern County is unlike any other part of California. 80% of the oil produced comes from Kern County. 95% of the well stimulation, what we call hydraulic fracturing, done in the state is here. Dogger issues thousands of permits every year for a variety of activities just in Kern County. And the new requirements on well stimulation that the legislature has instituted through SB 4 will increase that. Your board's direction on all projects that the planning department brings forward is to streamline and balance regulation with environmental protection. Therefore, we are proposing an over-the-counter permitting system. These types of permits are called ministerial. They're like a building permit. If you come in and you comply with the long list of requirements, you get a permit. Monitoring would be done in the planning department as well in regards to compliance at various steps as they implement the permit. No public hearing is involved, but there is a long line of notifications that will be involved in split estate, which we will talk about in another portion of this presentation. Text of the entire proposed zoning ordinance presented in Appendix A of your staff report. So how do we characterize 2.3 million acres? Well, first we divided the project into 3 sub-areas, a western, a central, and an eastern area that was designed for the environmental review and description of impacts. It loosely relates to I-599, and it actually fairly well corresponds to different water basins in the valley portion. We also commissioned a new online mapping system called Data Basin. We created a Kern gateway with resource information on every parcel in the project area that is on the planning department's website. You can put in an assessor parcel's number. It will take you to the parcel, and you can see the various layers. You're in a floodplain, what types of species could possibly occur there, what are the characteristics, the zoning, and we intend, if approved, to continue to add other layers to that Kern gateway such that people have information about not only their parcel but adjacent parcels. We then took these 3 areas and we incorporated them as zoning areas as tiers, tier 1 through 5. This entire is described on page 8 and 9 of the staff report. And the distinction is that tier 1 are areas defined in areas in which oil and gas are the primary land use. So these tier maps distinguish based on detailed aerial photographs, extensive field research by our staff, different ways of characterizing the properties. Tier map. Okay. So tier 1 is in the gray, and those areas are primarily oil and gas as the land use. And if we could have, there we go. Tier 2 areas are defined as areas zoned exclusive ag or limited ag, which have oil and gas but are mixed areas of use, meaning there's some oil as either existing already or as an emerging trend, but the primary land uses are rural areas in agricultural uses. Tier 3 areas are areas that have a variety of oil and gas, but they're not in a tier 1, that are designated as industrial, heavy industrial, floodplain, drilling islands, and PE, petroleum extraction. And then tier 4 are zones that require a conditional use permit. So those are residential and commercial zones. We've reserved tier 5 for those large pieces of land that a developer comes forward and wants to do a master plan community or some sort of industrial specific plan. So an example of this would be at the base of the Grapevine, where Tejon Ranch has the Tejon Commerce Center. There's actually a lot of oil and gas production down there, but they actually have already adopted through a separate EIR and a separate process rules for how oil and gas is implemented. So if someone wanted to do a large-scale specific plan, they could use these rules, go through a EIR, and come up with more restrictive rules or equivalent mitigation. They could not go through a process and come up with less restrictive without substantial evidence in the record that the environmental impacts have been mitigated. So the basic format of this local permitting, let's go to the summary of permitting slide, is two different types of permits, an oil and gas conformity review and a minor activity review, and they have specific pathways and timelines. So a matrix of the zoning ordinance details what types of permit is required for each activity. It is proposed to be incorporated into the zoning ordinance, and it's on page 13 through 17 of your staff report. And as you go through this matrix, you look to see, I am reworking a well. This is an existing well, and I want to re-drill it and make it deeper. That requires a conformity review. Routine maintenance on a well, I'm going out, it's existing, and I'm taking an engine off, does not require a permit, since that is an existing, legally established activity. So we have carefully gone through, characterized all the activities, and then created this matrix such that we can distinguish the difference between our built environment, since we have 58,000 active wells, and our new environment moving forward if your board approves this permit. So in Tier 1, there is one pathway. There are notifications in all pathways, but in Tier 1, it is a 7-day review pathway with a site plan, with a 30-day notification, even if it's split estate, meaning the surface owner and the mineral owner are different. So in Tier 1, which is primarily the Kern oil fields, the Belridge oil fields, the Pozo oil fields, it is just oil and gas, for 99% of what the land use is. There is one pathway. In Tier 2, 3, and 5, there are two pathways, which we will walk our way through in a moment. In all pathways, once again, we are replicating the state's requirements that 30 days before you submit an application to the planning department, you need to notify the surface owner, or you need to show the staff that there is a waiver by the surface owner. If you are the mineral owner and the surface owner, then obviously that notification is not required, and we would need we will have a process of validating that information, and you need to provide us evidence that you actually hard copied with an address the surface owner. So the primary difference between these two pathways, since this is a ministerial permit, meaning there's no discretion on the part of the staff planner, is simply whether you have the signature of the surface owner on the site plan. It's not a discretionary action based on whether you have complied with something. If you have a certain kind of report, you go through a longer process. There's only one criteria. On the site plan itself, there is a statement which has been incorporated into the zoning ordinance that needs to be signed. And it says, the undersigned surface owner is the owner of assessor parcel number, and then whatever the number is. The undersigned is the mineral owner or the operator or leasee. The land surface owner and the mineral owner and the operator have come to an agreement regarding the use of the surface of the property in connection with the Kern County permit that is being issued with the site plan. There is no requirement, and the planning department is not interested in seeing any surface agreements. It is not, the way that this is designed, it is immaterial how that signature is obtained. It could be obtained through an agreement. It could be obtained through just asking and they signed it. It is incumbent on the two surface owners and mineral owners to work out their private agreement. And in many cases, there are already agreements And we could then accept a letter from the surface owner saying that they already have come to an agreement and they'd like to waive their signature. They don't want to be asked again on these thousands of permits. They are satisfied, and they can provide that letter as a waiver directly to the planning department. We are requiring in the zoning ordinance that we get a specific letter to the planning department. We are not going to be reviewing past agreements and coming to a determination of whether there's a waiver in it or whether it's sufficient. We need a new letter, and we also need it dated, and we need it so that it tells us a time limit. This letter is good for the next 5 years. This letter is good for 1 year. Whatever the distinction is, but they only have to do that once. So if they're in Tier 1, or if they are in Tier 2, 3, and 5, and they have that signature, then they're in the oil and gas conformity review process of the first review is 7 business days. The planning department will provide a response in 7 business days. Now, the list of conditions could be as many as, there's 88 mitigation measures, so it could be as many as 100 things on the checklist. We certainly are going to provide a handbook, an implementation handbook that works our way through this. But it is incumbent on the applicant to submit a complete application. They have to submit evidence of their notification. Who did they notify, and what is the name of their split estate owner, if they have one, and a complete site plan and all of the requirements. The planning department at the end of 7 business days will send a letter back that says, you have done everything, here's your permit, or you are missing 2 or 3 of these items. They then take whatever time they take to put together a package and resubmit it to the planning department. If it is a second submittal, it goes to the top of the list, and it's a 3-day review by the planning department, 3 business days. So the second review is 3 business days. At that point, we hope they've complied with everything and that we can issue a permit. The zoning ordinance, this is all written specifically into the zoning ordinance that is proposed. The third review, we are asking for a mandatory in-person meeting for assistance. Our concern is that with so many things on the list and our experience with these types of processes, we do not want consultants or others to string out this process artificially. I'll turn in 10 things, then I'll turn in 15 things, then I'll turn in 20 things. So we're actually requesting a mandatory in-person meeting with the applicant and their representative with the planning department. It will also provide excellent feedback to us that perhaps we're not communicating effectively. Perhaps we need to change something in the handbook, or perhaps we're just not all on the same page on what the compliance requirements are. Once we issue the permit, the ordinance allows for the oil and gas company to hire professional certifiers. So they can hire a PE, an engineer who can put his stamp on something and certify that the setbacks have been met. Prior to any activity besides our permit, they would need to have a Dogger permit. So with 2 permits, Dogger would be looking at the underground. They would be relying on the mitigation measures that are proposed in this environmental impact report. They would be looking at their field rules. They still retain the right, because it is their jurisdiction, to put the necessary conditions on that project to make it safe and to meet their requirements. So there is nothing in this zoning ordinance or nothing in what we're presenting to your board that gives the planning department or other people, like the fire department or anybody else, the authority to say, I think you should have more concrete, or I think that your abandonment process is not appropriate. We have carefully distinguished between the authorities of the state and the authorities of yours, but the EIR covers all of it. So it is a comprehensive conversation, and we have addressed many of the concerns in mitigation measures. We also have a provision if people self-certify and fail to follow the rules. We have provided in the staff report the steps for permit revocation, which does require a hearing, which is appealable to your board, all the way up to criminal sanctions. These are all requirements under the zoning ordinance that you can enforce. And certainly, if we discover, we will have a full-time compliance person. If we discover that someone has self-certified in error that in error, that essentially it's not 210 feet from the house. They self-certified as 100 feet from the house. We have a provision that, they will not be able to self-certify for some time until we are confident that they understand that their professional certification needs to be accurate. In Tier 2, 3, and 5, if the signature is not secured, so stepping back 30 days, which is what the state of California has mandated for a notification. The zoning ordinance also provides that the planning department's brochure or whatever information we're going to give the surface owner will also be included in that so they understand the process. 30 days before they submit the application, they need to give the site plan to the surface owner in a split estate. So as a reminder, split estate is when the surface owner owns the property and a mineral owner owns mineral rights, and they are different from the surface owner on private land. If the signature is not on the site plan, the mineral owner can still proceed. They can come and submit an application. However, instead of a 7-day review, they are into a 90-day review. So the first review is 30 mandatory calendar days. And during those 30 days when the project is being reviewed, the planning department will reach out to the surface owner and invite them to come to a meeting with the planning department, and a planner would be assigned to this, a higher level planner than our permit specialists that we're proposing to process permits, who can walk their way through the permit, explain the site plan, explain the mitigation measures, and explain that many of the traditional concerns that have been raised are now conditions of approval already in regards to where drilling islands can go, site access, how chemicals are handled, what happens when you have a spill, what about biological and cultural monitoring wells. All of those are included in those 100 conditions. So after the 30 days, we will send a letter back to the applicant. We will indicate the status of their project. Either they complied with all 100, but they still don't have the surface owner's signature on the site plan, therefore they are still into a mandatory second 30-day review. At the mandatory, and we will ask the applicant to come in and share with us if there's anything about the site plan that they'd like to modify. When a site plan is modified, it automatically must be given to the surface owner again. So the applicant cannot make modifications to this without notifying the surface owner and providing them. The planning department will also be providing those modified site plans. Second mandatory review, we will invite the surface owner to meet again and discuss the site plan and any modifications that have been provided by the applicant. If at that point all 100 compliance, whatever the number is, haven't been complied with, every review after that is another 30 days. If at any time they get the surface owner's signature on the site plan, they immediately go to the 7-day streamlined permitting process. If at the end of 2 reviews, they have everything complied with except for the surface owner's signature, we will issue the permit. But it will be a conditional issuance. And one of the conditions will be is that they cannot drill for 30 days. And during that 30 days, we will be working with the applicant to establish a on-site monitoring program, a building inspector, who will be on site. If they drill 24 hours a day, which many times they do, there will be a building inspector in shifts on site to monitor compliance. They're not monitoring for Doggers requirements, but they are monitoring for the Kern County permit requirements. Now we have added to the zoning ordinance a option. It is only an option. It is not a guarantee, but we have added an option that an applicant could make a request to the planning director to combine 24-hour live streaming surveillance over the web to the building inspector in conjunction with on-site inspections. This is only a request, it's not automatic. We would review it for privacy issues, we would review it for comprehensiveness. At this point, we're not sure that it will completely address all of the construction that needs to be looked at, but we have been informed by many of the oil companies that they may drill for as long as 42 days straight, 24 hours a day. This could cost $500,000 for a oil company. 4-month delay, $500,000 for this process. We believe that that second pathway is incentive for the mineral owner to come to some agreement with their surface owner. And if they don't come to agreement because of a variety of market issues, we will still be issuing them a permit, but we will be assuring ourselves and assuring the surface owner that we are able to make sure that everything's been implemented. This monitoring is only on construction. Once the project is completed and they are operational, there will not be an on-site monitor, there will be no 24-hour surveillance, there will be no video cameras, if that was accepted. However, we will continue to have a dedicated oil and gas compliance inspector so the surface owner can turn in complaints. They aren't doing this, they aren't doing that, they said they were doing Y. You need to come out and check this out. We believe that this pathway fulfills your board's referral to come up with a way of creating a relationship between the mineral owners and the surface owners without having the county interfere with market forces. As a reminder, right now, if this zoning ordinance is not adopted, the rights that the dominant estate has, which is the mineral owner, to access their minerals, provides only a 30-day notice, a dogger permit, and they can move in and drill for oil. And the conditions and the mitigation measures that we have proposed would not be imposed. So we will come back to some of these issues, but that is a short version of the pathway and split estate. We are certainly, and council is prepared to answer any of your questions about split estate. There is a third type of split estate, which is, there's about 200 and maybe more than that, about 300,000 acres. This is where there's private land on the surface and Bureau of Land Management land underneath. So all minerals owned by the federal government are managed by the Bureau of Land Management, wherever they are. If they're in a national forest, they're still managed by the Bureau of Land Management. And the federal government never sells mineral rights. They only lease them. But we actually have a split estate that the surface is private land under your jurisdiction. And we are in conversations with the Bureau of Land Management on how they are very supportive of this environmental impact report, on how this works with dogger permitting and the recent MOU that they have signed. That split estate resolution would be under the Bureau of Land Management's jurisdiction, which your board has been provided in the addendum, how they resolve split estate. I would note that they have a process. They talk about good faith. You know, if you make a good faith effort, then they'll move forward. That word is very discretionary to me. I don't know how the planning department can make a determination of what good faith is. And in that case, the Bureau of Land Management is the mineral owner. So they have a different vested stand than the situations we're talking about. So we have not elected to accept that Bureau of Land Management process, and instead we are proposing the 120-day, 4-month, no self-certification pathway in an attempt to help support communication between the surface owner and the mineral owner. So we have provided in the staff report and at the joint workshop that you attended with the Planning Commission, a list of many of the concerns in this 2-year process that we went through with stakeholders. And some of the concerns that came from the surface owners in the agricultural areas, some of the examples were, they create new access roads when there's a perfectly good access road. They The distance from the residences and water wells. There's lack of maintenance after operations. We have proposed conditions and mitigation measures to address all these. So whether a surface owner comes to an agreement or not with a mineral owner, your board's process will be resolving many of these. And we have also taken out of the mix some discretion that used to be in the setbacks because of the environmental impact report. So it used to be that you could work out with your surface owner to be closer to a house, obviously perhaps for compensation. And through the EIR, we have determined scientifically based setbacks that are not, you cannot waive them, because we believe that that's not protective of people who could live in the house after the current owner sells them. So we do agree that we have taken the flexibility out on certain environmental negotiations between surface owners and mineral owners, but nothing stops a surface owner for negotiating more environmental protections. They will just not be enforced by your board or the planning department. They would be enforced through a private civil agreement that is between the two parties, including any compensation. So we have continued dialogue with all the stakeholders the last 3 years. I would say that all of them have common themes of support for oil exploration and extraction, but they also have concerns for the ability of the surface owner to coexist and be part of the site plan formulation. I would say that where we diverge is how much involvement the county should have in resolving these issues. And we have based our recommendation on many, many years of working in the planning field and recommendations and policy direction from your board that the proper regulatory position for government is protection of the environment, protection of neighbors, but allowing business and market forces to resolve their own issues as much as possible. We are also cautious because to remain a ministerial permit, an over-the-counter permit, we cannot add discretion to the system. And so we've been carefully reviewed this with legal counsel. There are many legal background documents that are provided to you in the staff report. And of course, as we move forward, in today's discussion, we're available for questions on the pathway and split estate. I'd like to move to the processing structure, just to highlight that the government processing fees, which will come to your board if you approve this in December, so they're not before your board today, but we would like to make it clear that this is a complete package that we put together, and we would need new fees since the government code requires that if government does work, we must fully recover our costs. The government processing fees is $1,250 in oil and gas conformity review. I would note that we have provided to your board in the staff report the fees for other jurisdictions, which are significantly more than $1,250, and many of them are time and material. They're in the many, many thousands of dollars. Of the $1,250, the planning department staff only has $660 of that fee goes for planning staff and review time. It's a flat fee, no time and material. The other fees are various maintenance fees we need for general plan and zoning, keeping the zoning ordinance, the oil and gas conformity review, staffing for public works for drainage review, but the total is still $1,250 one-time fee for the oil and gas conformity review. Now, the second type of permitting is a minor activity process. Same streamlined review process, 7 business days, 3 business days, self-certification. We are not requiring a surface owner's signature on minor activity reviews because of the nature of the process. A minor activity review, an example would be, we have an existing oil well. It's been operating for many years. It's legally been established. They did something with the surface owner. Either the surface owner inherited a surface agreement, the owner bought it with the with the well on it, And now they want to replace a tank. They want to take a tank that's there off and put a tank on. Minor activity review, $300. It does require notification of the surface owner. We would then go through and determine, as a legal nonconforming use, were they disturbing new land? If they're disturbing new land, they're making it bigger, then we have certain mitigation measures that apply. However, we do believe that asking for the surface owner to sign the site plan for a minor activity review gives them a second or third opportunity to unwind legally valid surface agreements, and there is a concern that that is not an appropriate direction for us to go from County Council. In other words, these are legally established, although they did not get a permit from us, they were legally established prior to the adoption of this EIR. They have a right to exist as long as they're in compliance with the Dogger rules, and as long as they keep it within the bounds of the 14 things in the zoning ordinance, meaning you can't have a tank farm with graffiti on it. We do have the right to go out and tell them to take the graffiti off. They don't have the right to store concrete on an oil drilling, old oil drilling site, because concrete storage was not allowed when they got their permit. So there have been comments from surface owners who said they also want a site signature for minor activity review. We are not recommending that, and certainly we can answer your questions about that at the appropriate time. So there will be new staff positions for permit specialists and planners for processing in the 7 days. As a reminder, we are talking 1,800 to 2,000 permits a year. And we are committed to complying with the 7-day review and the 3-day review. We are also going to have a dedicated oil compliance inspector in the planning department, since they're going to be integral to the process. And we are also expanding the current Acela permit system. So this is an existing system in Public Works where there's online permitting through the building department. The planning department is now going to have a module so that we can have online permitting and streamline that. And there is a public portal to that permit which we will open up, which means that the public can then go and look to see what is the status of permits. Is something happening near me? What is happening around me? How is this permitting going? And we believe that that is a fully integrated online permitting system, which has already been budgeted. The planning department has been working on that for many years, and so it was already budgeted. We're going to bring that online and help with this along with the Kern Gateway. In addition, on page 28, we'll be proposing, when we bring the new fees forward in December, if you approve this project, various policy services that we would recommend you direct the planning department to institute. Obviously, we believe that we should have industry education workshops. We should reach out to consultants to work our way through. We will be doing a handbook that will be available to the public. We want to do surface owners educational workshops in conjunction with the Farm Bureau and create brochures that would explain how the process works and what options they have. We would be proposing a small producers assistance program. So we've worked with SIPA and IOPA to identify that we have people who do 1 to 10 wells a year. They are considered small producers. And we are going to propose that we have a special handbook for them, that we go and hire a consultant who can actually put together a site plan, a drainage plan, a sample worker awareness program, a sample dust control plan, and actually have a off-the-shelf, make it fit for your project way of assisting people who only do 1 to 10 wells a year. They will certify that they are not a division of a larger company, so it's not a division of a company that does thousands of wells. We have worked very hard to keep the cost of this program reasonable while still ensuring that we have sufficient mitigation. And those costs for that, and then we will also be proposing to your board that we retain on-call flat fee biologists, archaeologists for these small producers so that they don't have to go out into the market and look for whatever necessary consultants they have. So we've carefully worked this out with the industry. We're trying to be responsive to these concerns and comments you've received about cost. In addition, when the fees come forward, we will be proposing that some of the fees that come to county government be waived for those small producers up to 100 permits a year. Once again, those would all be under a separate consideration by your board with a separate public hearing. And in that public hearing, we are also looking for your direction on a legacy oil activity program. So right now, if we get a complaint about an existing oil well, we send them to Dogger, the state of California. You know, we didn't permit it, and we don't have jurisdiction over it. So unless there's a specific building inspection issue, we are not involved in that. If this is adopted, we will be asking your board to give us some parameters in a legacy oil program. We believe that it would be important for this oil and gas inspector to act as liaison with Dogger, that we would take complaints on idle wells, which we'll be talking about in a moment, and we help make sure that Dogger pays attention to these complaints. We certainly can address issues of is the oil, is it truly an established oil activity, or is that site suddenly attracted other sorts of uses? They're storing equipment there which is non-oil field related, or they're storing concrete is one that came up. Those are violations of the zoning ordinance, and we would actually recommend that your board let us go out and start to enforce those rules and work on that issue. In addition, we would act as a liaison for just the fundamental questions that are going to come up now that we have a local permit. So I want to summarize for a moment the final environmental impact report. We have provided you all of the information on this, but I'd just like to give you a summary of some things. So the public process for preparation and consideration of this EIR under the California Environmental Quality Act is detailed in the state statutes and guidelines. But for this process, we actually expanded the outreach and notification because of the size and interest in the project. The public process included 7 workshops all around the county, including an all-day joint Board of Supervisors and Planning Commission workshop to take public comment during the circulation of the document. The comment period was extended from the statutory 45 days to 66 days, and we continue to accept comments today. Spanish translation was provided at all the workshops, the Planning Commission hearing, and today. Over 2,100 total individual public notices were sent throughout the process, as well as putting display ads in newspapers countywide and online. The EIR contained the draft text of the ordinance. It was available online and in all 25 library branches, including Cal State University Bakersfield Library. The staff report and supporting information given to your board, including what has been given to your board today, has been available online, and we have emailed notification of new online content to stakeholder groups that have requested notification. Throughout the process, your board has received documents for review, and the final EIR now comprises volumes 1 through 5. As you know, extensive detailed comments have been made on the EIR. We provided you with the response to comments. But after the response to comments, more extensive comments were provided, as well as at the Planning Commission and as recently as today. These comments, along with our responses and recommended clarifications, are included in your staff report. The addendum, which was released to you Friday night at 5 o'clock, we also noticed that addendum with our responses to the recent information we got on the planning website Friday night at 5 o'clock, and we emailed out the link to all the stakeholders and all the commenters, as well as Ms. Kraus notified the agenda list that she has. I'd like to note that a comment submitted on Friday night, just after the close of business, was received from Shute, Mahaly, and Weinberger, representing Pacific Ag Management. Outside counsel Holland and Knight, at the request of County Counsel Teresa Goldner, has prepared a response to this comment. I would like her to summarize that, as well as the comments that we received at 12:48 last night from, I believe, Earth Justice, which we have also reviewed, and which we will be providing a response from our legal counsel.
Chairman and members of the board, I'd like to introduce Attorney Jennifer Hernandez. As Planning Director Oviatt has said, she is our outside counsel working on this CEQA matter. She's been working very hard over the weekend, and along with staff, to respond to what we refer to as late hit document dumps that were received by a law firm. The first one was a 49-page comment letter, which was received late Thursday, November 5th, with attachments that were on a CD that were received on November 6th. Further, there was a second document dump by that same law firm, which was received late in the day on Friday, November 6th, just moments before the close of business, which means that it was strategically timed so that the county staff would not have an opportunity to print it and review it that day. Nevertheless, county staff worked very diligently over the weekend to be able to do that. And third, there was another document dump, as Planning Director Oviatt said. This one was received by Earth Justice at 12:47 this morning. I'm going to turn it over to Attorney Hernandez, who will respond to all of those.
Thank you, Ms. Goldner, and Mr. Chair and members of the board. It's good to be back. This is, in fact, a common tactic in CEQA matters where litigation is expected for law firms, and we're talking two law firms here. Earth Justice is a law firm, and Shoot, Mahali & Weinberger is a law firm. Late hits of the nature that Ms. Goldner just described. Both of the long letters that were submitted by the law firms really restate arguments that we've previously seen from them and that were responded to in the final EIR. We were able on Friday to complete a written response to the comments we received on Thursday. And those comments are, and those responses are in your staff report. The comments that we received after close of business on Friday included a new technical air quality study, which largely raised issues that could have been raised in response to the draft EIR that was issued this past summer. They were quite untimely. They fell into a variety of categories. I'll just illustrate three. One are highly, highly technical disagreements among experts. How do you speciate, how do you divide different constituents of emissions from construction activities? There's different ways of doing it. Our expert team chose a way that they believe is appropriate, consistent with agency practices, and the expert or consultant hired by Shoot, Mahali & Weinberger disagreed with that approach. Disagreements among experts are common in CEQA controversies. The lead agency has the discretion to go with its expert. A second example is a challenge really to a quite fundamental air quality mitigation practice in San Joaquin Valley, which is the use of emission reduction agreements and offsets to mitigate air quality impacts. This is a challenge that this county has faced before and won in court. It's a challenge to a practice that is well established in law, and there were several disagreements that fall into that category. Finally, there was a disagreement about the adequacy of the time provided to allow for this particular consultant to review documents. Another common technique in CEQA litigation is to request all of the underlying worksheets, highly, highly technical spreadsheets that are indecipherable to the general public and which are inappropriate for inclusion in an environmental impact report document, which is supposed to be a disclosure document accessible to the public. So we received Public Records Act requests that from Shoot, Mahali & Weinberger or their colleagues or clients that sought that raw data, and when the raw data was created, the comment came back is now we don't have enough time to review the raw data. In fact, the comments submitted don't really spend much time on the raw data, and then the second point that was made is, my gosh, look at all this raw data, we can't understand it, and it just came out. We need more time. So these are examples of litigation mitigation tactics, and frankly, we're continuing to maintain the same approach that the county's done throughout, which is to provide information in a very transparent and open way when requested, and to respond to comments as we've received them. We were able over the weekend to prepare a response with the help of the county's technical consultants to all of the late-hit air quality comments received on Friday, and that was in your supplemental material under my letterhead today. I can't say that we were able to respond to the document that we received at 1 a.m. this morning in writing. We have looked at it, we've reviewed it. It, like the Shoot-Mahali letter, really starts and stays with restating comments already made, and we're continuing to review that. But at first, second, and third glance, it looks pretty familiar. The 1 a.m. letter also included yet another air quality technical report, this time by a consultant retained by Earth Justice law firm. And in going through that, it too seems to fall into these same categories of either methodological or legal challenges to longstanding practices that our consultant has initially reviewed and concluded is not raising any issues of concern. And with that, I'll stop unless you have further questions.
I don't think we have any questions up here right now.
Thank you. So in conclusion, on the final environmental impact report, which you have received and has been posted online, on page 39 is a summary of some of the highlights of the mitigation measures which were presented to you at the joint workshop. All comments have been included in the record. Written responses have been provided where we have been available, and we have now provided verbal responses. And your board needs to know, based on our legal counsel, that the EIR is in full compliance with CEQA and the whole of the record. We have provided for your consideration findings of facts, statement of overriding consideration, and a list of, page 50 of the staff report includes the benefits that could outweigh the unmitigated environmental impacts, including a report on the economic contribution of the oil and gas industry in Kern County from the Kern Economic Development Foundation. This project was considered by the Planning Commission on October 5th, 2015. 4 commissioners were present at the hearing, with Commissioner Poole absent. After public testimony included in the staff report, the Commission voted unanimously to recommend approval of the project. You have received an addendum at 5 o'clock Friday night electronically. We have given you a hard copy today, but you did receive it Friday night along with the public. We placed it online and we let everyone know. And I'd like to touch on some of the organizational letters and provide your board with some responses, because I do believe that these are these could be remaining areas of disagreement that you hear today. First, I would like to summarize, for the moment, the public comments. So emails and comment letters against adoption of the project to EIR, we have 63, which include these organizations. Petitions asking your board to protect disadvantaged communities and ban hydraulic fracturing or fracking, over 800. And support, there are 2,700 petitions and emails, plus various legislators' letters which you've received, including Senator Fuller, Senator Vidak, Assemblywoman Shannon Grove, and House Majority Leader Kevin McCarthy and Congressman Valadero, all supportive of you moving forward with this project. One of the issues that has been raised in the addendum by various people is the issue of idle wells. So if we could have a picture of the idle wells. So there are 11,000 idle wells right now anyway. Idle wells are under the jurisdiction of the Dogger, and idle wells mean that right now it's not operating, and it's in various types of existence. You know, it could be a fully constructed with a pump jack and it's just not going up and down and nothing's being produced from it and it's an idle well. But the controversies have really been in Tier 2. If we could see that, there are, according to this, about 649 idle wells in Tier 2. Remember, Tier 2 are these emerging surface areas. You have seen testimony in your staff report that was presented at the Planning Commission from the Committee to Protect farmland and clean water, and their concerns that, the surface owner wants their surface back. We should do something about these idle wells. Staff has investigated this issue extensively. First of all, since your board did not permit these wells, you have no jurisdiction to say they should be taken out. They are legally established and are not under your jurisdiction. Second, there's a property rights issue here. As the dominant estate, the mineral owner has a right to have that facility in compliance with state law on that piece of property, and either compensated the previous surface owner, the current surface owner, or somehow there was a legal agreement for them to get access to it. And while the surface owner may want that surface back, it may not be appropriate for the county government to interfere in that relationship. So the question then becomes, what is our jurisdiction? So first, idle well complaints. So the state has established a regulation that idle well complaints can be filed by a surface owner within 1 mile of the idle well, or the person whose land the idle well is on. So someone from Ridgecrest cannot drive around Bakersfield, make a list of idle wells, and send them to Dogger, and Dogger will investigate. The regulations are very clear. It's only if you own property or operate a well within 1 mile of the idle well, or if you have the idle well on your property. So we took that regulation and we have written into the zoning ordinance 3 provisions. The first provision is that every year the Kern County Planning Department will request a list of idle wells from the state of California to let them know that we are watching these wells. We want to make sure that they are, we want to know where they are, so for our oil compliance inspector. Second, if someone is 1 mile from an idle well or has an idle well on their property and wishes to file a complaint with Dogger, they can also file that complaint with the Kern County Planning Department, and our oil compliance inspector will make sure that Dogger files a report on it. We have some anecdotal information that other counties have been more aggressive in this relationship with Dogger and therefore have gotten more attention. Are there, an idle well, unlike Texas or other places, can remain idle for many, many years, 20 years, 30 years. There are criteria for that, and does not need to be abandoned or plugged. We do know, however, that there are some wells that probably could have that criteria, and it would be incumbent on us, for your board, if you approve this project, to direct the planning department to be more of a liaison, to have Dogger pay attention to these projects. Now, those are different from orphan wells. Orphan wells are wells for which there is no identifiable operator, nobody owns them, and there is a fund in Sacramento to have those plugged and abandoned and handled. We do not have as many orphan wells as people think, but we do have some, and that is another place where we could act as a outreach and support with Dogger to make sure that happens with our local Bakersfield District Office of Dogger. That program was funded at $3 million. The funding has gone down. Another access for your board is to work with the legislature to get more money into that fund and to make sure that we access it. We have the largest number of idle wells. Idle wells are a concern now of the legislature on the coast. I do believe that there will be legislation coming forward in the next few sessions looking at perhaps putting a limit on the number of years in an idle well. And I would certainly recommend that we use our legislative lobbyists and use, our outreach from the county to keep track of those and voice our opinion about how long we think idle wells should actually be allowed to remain that way. There is a provision in the Public Resources Code that provides that a county can create a list of idle wells and using technical resources determine that there's no possibility that you can get oil out of the ground. I'm paraphrasing what it technically says, and ask them to be abandoned. We have investigated this, and we're not clear what that would cost the county, where are we going to find that kind of expertise to be able to weigh in on a market decision that there's no oil in the ground. The planning department has experience with this, has been through this in the last 20 years on tract maps when it comes to this question of waiving of signature, where the surface owner wants to do a tract and says there's no oil in the ground. And the mineral owner says, yes, there is. It is just not technically feasible. We believe that this public resources code is interesting, but we don't believe it's practical, and we would not recommend that your board expend hundreds of thousands of dollars of general fund money to manage this when there is a process with Dogger to file complaints on idle wells. And then the third issue is if there is an idle well complaint, and someone comes in to do a site plan, if we will then ask Dogger, this operator has an idle well complaint, what's happening with it? If they are found out of compliance, then we have proposed in the zoning ordinance that we not permit any new drilling permits, oil and gas permitting, for that applicant till they have resolved their issues with Dogger in regards to the idle wells. That is within your jurisdiction. And we have carefully written this. We have discussed it with the industry in regards to how that might work. This is no different than what we already have in the zoning ordinance, that if we have someone who has zoning violations, your board is directed that you are not going to approve other projects for them if they have zoning violations on other pieces of property that they have not resolved, so that we don't have a whole series of zoning violations and they just move to another piece of property. So that's the third piece on the idle well. We received letters from, including, as I noted, the 800 signed petitions from the Center for Race, Poverty, Environment. They would like a ban on what they call fracking, which is hydraulic fracturing. They state there are health risks associated with gas and oil production, such as air quality, groundwater, and seismic. They call on your board to protect them and believe that, that this EIR is not protective. Staff notes again that the state of Constitution preempts your board from regulating or banning hydraulic fracturing or other well stimulations. You cannot ban them. The EIR, however, does have regulations which are enforceable by a local agency to be protective, and we have provided the scientific studies to show what are the appropriate setbacks, how should we handle the chemicals, and we've also shown in this EIR that for the 60 years of hydraulic fracturing here in Kern County, we do not have any demonstrable impacts. And we certainly are not saying that as an industrial project there have not been accidents or spills or other sorts of things. But we did not find on a cumulative level extensive damage from these projects. What's more important that I would like to remind your board is that the extensive mitigations that are being proposed don't exist now. So we are proposing to test, identify, and monitor all pipelines within 300 feet of a sensitive receptor regardless of size, even though the state of California says that if they're under 4 inches, they're exempt. This EIR would say they are not. Mandatory setbacks are required from sensitive receptors, including schools, homes, and churches. There is extensive mitigation to require that their air impacts be mitigated down to 0 by doing other projects through a emission reduction agreement that will come before your board at a later date between your board and the San Joaquin Air District. This is not the applicant implementing these. It is your board implementing them through the Air District to ensure that all the air impacts from drilling, the employee vehicles are mitigated just as all other projects are, as well as new noise and groundwater. If your board declines to approve this project and certify the EIR, there are few and limited local regulations, or few and local regulations on oil activities in Kern County. And the regulation comes from the state, and their track record of protection may not fulfill your board's commitment to ensure the health and safety of our communities. Staff truly believes that the disadvantaged communities that the Center on Race, Poverty, and Environment are concerned about will be better protected with this environmental impact report than without it. Because if this project is not approved, then it is status quo. And the list of mitigations that we are bringing forward have not been imposed on the oil and gas industry up until now in Kern County. You received a memo in your addendum that looked at setbacks. It's kind of a compilation from Shoup, Mahaly, Weinberger of these larger setbacks all over the country, 1,000 feet, 600 feet in Colorado. We have provided our response, and I'd just like to point out that, providing a list of what other places do is not scientific information. That's just a list of what other people do. And many of those wells are different. So hydraulic fracturing in North Dakota, New Mexico, and all these other places is not what we do here. We've provided in the EIR an extensive appendix that explains the difference. And those are gas wells. Gas wells should be farther away from houses. These are oil wells, and the gas gas is extracted, but the type of shale gas that is extracted in these other areas does require these bigger setbacks, and many of those setbacks were political compromises by small counties who came up with their own determinations. This is California. We are a very dense oil density type of well structure here in our oil fields, and we have provided you with scientifically based health risk assessments that have been reviewed by the San Joaquin Valley Air Pollution Control District, who is the expert in the matter and concurred with our findings, and we have provided noise setbacks. The 210-foot setback for noise from sensitive receptors encompasses the health risk assessment. Now, there are larger setbacks for the occasional 10,000-foot well, which is not the normal depth at which we drill. Those will also be implemented. So I'd just like to let you know that. The last issue I would like to touch on is we received a thoughtful letter from the Kern County Cattlemen's Association, which is in your addendum. They raised concerns about the biological mitigation and whether this actually, in their view, provided permission for biologists and archaeologists to come unannounced onto their property. It does not. And we have provided our logic and our legal background. A mineral owner does have a right to access the property, and they are required to give at least 5 days notification. The request from the Farm Bureau and others that the county require pre-application notification runs into a problem because we actually don't have jurisdiction over that. Once they submit an application to us, we have jurisdiction, and we've put together a whole list of notifications that have to happen. And we've required that they give 30-day notification before they submit. But before that, when they do biological surveys if required, or they do cultural, it is within their legal requirements of whatever legal rights they have to access. And the state of California requires 5 days notice for that. The dominant estate has a right to access. That does not mean that a random biologist has the right to show up at a surface owner's property and say, "Hi, I represent an oil company. I can come in and look at your property." We are not saying that. Your board is not authorizing that. There is nothing in the mitigation measure that permits that. The second concern was conservation easements. We understand and respect the cattlemen's position on conservation easements. They do not support conservation easements. They believe that they are that they can change property values and also create a kind of a hostile environment for them. We appreciate that. We are required by law under the Endangered Species Act and the federal and the California Endangered Species Act to implement biological mitigation. It's just part of the California framework. We did note, however, that the oil industry, in many instances, has already identified areas in the oil fields. So Elk Hills HCP is in the oil fields, and their conservation easements would be there. The Low Kern is around the area where there's oil fields. The majority of this mitigation is going to be in oil areas. It's not going to be in agricultural areas or areas with the ranchers and grazing. However, we understand their position. Unfortunately, under the law, we must have these types of mechanisms in order to mitigate for the biological impacts. We have provided our recommendation language in the addendum, findings for your consideration. That completes staff's presentation, and we are certainly available for questions when appropriate. Unless council has something else they'd like to add.
Nothing further from council at this time.
Okay, thank you. So now would be the appropriate time to open the public hearing. And again, there's a row, front row is wide open. We'd ask that if you'd like to speak, first in opposition. We're going to take everyone that wants to speak in opposition. I'm sorry. Oh, I'm sorry. We have a statement from the applicant. I neglected. There's a brief statement from the applicant as well before we open the public hearing. I apologize. Thank you.
Thank you, Chairman Couch. Fellow board members, Director Oviatt, county staff. My name is Suzanne Noble. I'm the Vice President of Production Regions and Sacramento Affairs for the Western States Petroleum Association. We appreciate the opportunity to speak in front of the board today. I have to say personally, I'm very excited to be here today. Most of you may know WSPA is a nonprofit trade association representing companies that explore for, produce, refine, transport, market petroleum products, natural gas, and other energy supplies in California, as well as in 4 other states. As you know, WSPA, along with the California Independent Petroleum Association, the Independent Producers Agency, is a project applicant for the proposed revisions in the Kern County zoning ordinance and the accompanying environmental impact report under the California Environmental Quality Act. Together, the 3 applicant associations represent over 30 companies. WSPA appreciates the county staff's tremendous hard work to prepare and propose amendments to the zoning ordinance and a final environmental impact report that ensures that oil and gas activities in Kern County will continue to be carried out in a manner that is protective of the environment. Kern County should be very, very proud of its monumental effort and accomplishment, which covers all oil and gas activities and exploration and development in Kern County. I will try to be brief. Director Oviatt did a fantastic job going over several of the environmental requirements, safeguards, and other topics of interest within this massive document, but there is a couple of items that I do want to just take a few minutes to reiterate, and I'll do it as briefly as possible. The proposed amendments in the zoning ordinance comprise of comprehensive update to the existing procedures, implementation standards, and conditions for the oil and gas exploration, development, and production activities. The revised ordinance creates a streamlined permitting process that will help further responsible oil and gas development, while at the same time protecting Kern County's numerous and valuable environmental resources through, again, compliance with 88 mitigation measures set forth in the final EIR. The final EIR analysis and mitigation measures address both project and cumulative impacts for all oil and gas activities and development activities in Kern County. The mitigation measures impose many new and very costly requirements and safeguards, which will significantly affect industry operations, especially in the context of current low oil prices. WSPA members are willing to undertake these many new and costly requirements in order to obtain the economic certainty of a streamlined permitting process. Having agreed to do so, we cannot accept any additional concessions or additional costs. We know that you will hear concerns today, in particular from a few stakeholders and surface owners of split estates. No less than 49 of the 88 mitigation measures in the EIR directly benefit or protect surface owners, including owners of agricultural lands and split estates. These include a requirement for one-to-one mitigation for use of activity farmed lands as specified in mitigation measure 4.2-1. No further mitigation is required under CEQA to address impacts on agricultural resources. And I think that's important enough to say again. No further mitigation is required under CEQA to address impacts on agricultural resources. The revised zoning ordinance further protects the established land uses by providing notice requirements and extending timelines for review of activities on split estate properties, incentivizing mineral owners to contact and cooperate with surface owners. Specifically, WSPA is not opposing extended timeline for oil and gas conformity review with a surface owner without a surface owner signature. The requirements of a 30-day notice, 2 30-day review periods, additional 30-day review periods if the application is deemed incomplete, and a 30-day post-permit period for coordination before construction can begin add up to a minimum of a 120-day wait period. This 4-month process quadruples the delay before the mineral owner can access his or her mineral resources compared to the 30 days provided within state law. These delays are not trivial. Given more than 100 years of coexistence of oil and agriculture in Kern County, WSPA members are willing to accept the extended timelines as a compromise with agricultural stakeholders who have expressed concern. However, WSPA is not willing to compromise further on a requirement for a conditional use permit where surface owner sign-off has not been obtained, as some agricultural stakeholders have suggested, which would give surface owners a veto on the county's ability to issue ministerial permits. These issues ultimately are about economic relationship between surface and mineral owners, not about environmental protection. The staff proposal is carefully crafted to avoid placing the county in a position of favoring one property interest over another. We urge the board to reject the calls of a few agricultural stakeholders to disturb this compromise in place. In addition, I want to mention the revised ordinance and the EIR do address idle wells. I know we talked a little bit about that already, but I want to make sure that I re-emphasize it. Wells that are currently idle represent a valuable economic investment and can be restarted when the price of oil justifies doing so at a less cost, and this is important, with fewer environmental impacts than drilling a new well. Even idle wells are subject, as we discussed, to the state agency jurisdiction, DOGGR requirements that must be continuously met. Moreover, idle wells are a legacy of past operations and are not considered an existing baseline condition under CEQA, not an impact of this project. Nevertheless, the final EIR provides incentives for operators to address idle wells when drilling new wells Operators must mitigate both agriculture and biological impacts by a one-to-one mitigation, which may be provided by closure of idle wells as well as removal of other legacy oil and gas equipment. While all wells eventually must be properly, permanently closed in compliance with regulatory requirements, the one-to-one mitigation provides an economic incentive for operators to close idle wells sooner, which can be less expensive than other mitigation options, such as purchasing conservation easements. The amended zoning ordinance also requires operators to notify surface owners of changes in idle well status, as we talked about. It enables surface owner and residents to ask the county to confirm an applicant's compliance with DOGGR requirements for idle wells. And it also prohibits issuance of permits to those applicants that DOGGR deems in noncompliance. This is another example of industry's willingness to compromise with surface owners and stakeholders interested in legacy conditions. Among many of the other new requirements, I just wanted to reemphasize and point out, as was discussed earlier by Director Oviatt, the revised ordinance will require all operators to comply with protective setbacks for homes, schools, and hospitals. These include a minimum of operational noise setback of 210 feet from any sensitive receptor, such as at a residence or a school, as well as increased setbacks. Depending on the equipment used, larger setbacks may be required to avoid construction noise impacts as specified in mitigation measure 4.12-1. These setbacks are not arbitrary, but instead are based on technical analysis of project-related noise exposure and health risk. Some setbacks are request larger setbacks and point to larger setbacks adopted by other jurisdictions, as mentioned earlier. However, larger setbacks are not necessary here according to the technical analysis prepared for Kern County. In closing, California's energy industry leads in innovation and environmental stewardship. We strive to operate in harmony with our neighbors and communities and in compliance with all applicable regulations. California-based oil and gas production, in particular in Kern County, provides an essential supply of energy that keeps our economy and our citizens moving forward. The industry's future, as well as the county's economic and environmental future, depends on all of us moving this process forward. For these reasons, we respectfully request that the Board of Supervisors certify the final EIR and adopt the zoning ordinance amendments. We would like to thank the supervisors and the county staff for your interest in and commitment to this effort. I want to personally thank you all for your time today.
Thank you, Ms. Noble. Are there other applicants that need to make a statement before we open the public hearing? Okay, seeing none, we're going to open the public hearing. We're going to ask for those that are here in opposition. We have about 4 seats down in the front row. Please come forward, state your name. You don't have to tell us if you're from here or not. Just state your name and proceed. Yes, ma'am. You get to be first.
It's an honor. Thank you so much, Chairman, members of the board, and Director Oviatt. Good to see you again. I applaud your work in creating an ordinance to give jurisdictional power to the county. So I'd like to make that very clear. However, I do believe that your overriding concern as this board is the health and safety of people. While 1 in 7 employed people in Kern County may be employed in the oil industry, 6 in 7 are not. And that represents only employed people, not children, retired people, or disabled people. And so I think that employment, generation of tax dollars, property taxes, is not really an overriding concern when you compare the emissions and health and safety of the people of the county. There are two matters which I think directly impact this. One is the setback, which in fact begins only at 100 feet, not 210, and 210 is only perhaps 3 times the width of this room. So in the real world, 210 feet is not a very great distance. The 300 feet minimum all across the nation is in fact wise, and it is expanding simply because of the different technology of the fracturing processes. While they may be slightly different here for oil than they are for gas, they still entail incredibly detrimental chemicals, which under this ordinance would be allowed to be stored and transported virtually without supervision, because they're given the right to do so in this ordinance. So I sincerely request that, due to the overriding concern of the health and safety of the citizens of Kern County, that you revisit these very easily established minimum setbacks, minimum distances, and the kinds of chemicals that are actually being used in these processes. Thank you very much for your time and your work on this.
Ma'am? Excuse me, ma'am?
Yes, sir.
Could you give us your name for the record?
My name is Wendy Reed, R-E-E-D.
Thank you.
I had comments. Kathy, do you want?
Sure.
Good morning, members of the board. My name is Susie Snedden, and I'm a cattle rancher and property owner with property in the project area, some of which is split estate surface where other parties own the mineral rights. I'm also here today as a member of the Kern County Cattlemen's Association, or KCCA. Our members have expressed support for the Kern County oil industry and appreciation for the planning department's efforts to support that industry. And we have originally taken a position of opposition because of 2 components in the EIR that we don't believe were adequately addressed in the response from the staff. The KCCA was brought into the project discussion late in the process, but our members are important stakeholders owning both mineral and surface rights in the project area. The most recent Planning Department staff report summarized KCCA's concern, quote, that the mitigation measures under CEQA that require biological and cultural resource surveys give authority or county direction for unauthorized access to the surface owner's property. They have asked for specific language in the zoning ordinance to make it clear that access to the property for such surveys can only be at the express permission of the property owners. That was a good restatement of our concern. We do not agree with staff's conclusion that express language is unnecessary. They had referenced that language setting parameters for these surveys would be in a guidebook or handbook, and we would ask that this language be expressly put into the body of the ordinance itself. And we would ask that we could revise our statement that we had submitted in our comment letter last week to read as this way. Quote, the decisions generated by this amendment only apply to the mineral estate. No decisions generated by this amendment shall change the existing rights or authority of the private surface owners to full use and enjoyment of their property or the mineral owner's right to pursue mineral exploration and production. The right to enter split estate private surface lands to permit oil and gas operations shall be limited only to the actual location associated with oil and gas activity, not to an entire parcel of property. The right to enter split estate private surface lands by individuals or entities for purposes of conducting biological and cultural resource surveys must be under the authorization of and liable to the mineral owner operator and limited to the parameters of the drilling location. And our other objection to the is to the amendment's requirement that land that is disturbed by oil activity is to be mitigated by the oil operator owner's, quote, recordation of a conservation easement or similar permanent long-term conservation management agreement in a form acceptable to the county for land within the project area on land that has mitigation value, unquote. The KCC directors voted to oppose the use of public funds and government-enforced purchases of conservation easements or land, which is the case in this amendment. A major portion of Kern County's land is already locked up in either government ownership or in designated conservation land. If CEQA requires that money be extorted from oil companies for environmental purposes, we recommend that the money, and after hearing the presenter, I would recommend the money goes into the addressing the issue of idle wells or into a fund to offset the taxpayers' costs of managing the existing government properties. Thank you.
Thank you.
My name is Gordon Knipp. I am the vice chair of the local Sierra Club chapter, and I do live here in Kern County. I just submitted what your out-of-town consultant has called a document dump. Because the county has been pushing this project through so fast, let me just suggest that the public has been the recipient of an unfair document dump. Unfair in the sense that the public doesn't have the option of continuing the hearing, whereas if you're interested in seeing what we've submitted, you do have that option. And in this context, let me just read a couple of short paragraphs from the Earth Justice letter that I just submitted. Despite the county's intention to address with finality in a single analysis all new oil and gas drilling activity in the county for the next 25 years, the county only afforded the public a meager 60 days to review the highly technical 1,800-page draft EIR and its 6,000 pages of appendices. The county has provided an even smaller window for review of the FEIR, posting the FEIR just a little more than 30 days before the Board of Supervisors is set to meet, and requesting unreasonably that comments be submitted within a few business days of the FEIR's release. Perhaps worst of all, a mere week before the board is set to meet, county officials just released the 1,600-page cumulative health risk assessment upon which the FEIR is based, along with a draft emissions reduction agreement that purportedly will mitigate air quality impacts. Such abbreviated timelines for review are particularly inappropriate because none of the decision documents have been made available in Spanish, even though Kern County is home to many community members who are monolingual Spanish speakers. In the face of such obvious obstacles to full public participation and transparent government decision-making, the Board of Supervisors should decline to make any decision on the FEIR or the ordinance at this time. Instead, the county should extend the comment period to allow for concerned citizens to fully assess and comment upon the CEQA documentation, including documents translated into Spanish. That from the Earth Justice letter. Let me just mention a couple of things. I'll leave specifics to the written comments, but let me just make a general observation. At a time when the overwhelming scientific consensus says that we should be transitioning away from the use of fossil fuels, this project and this EIR authorizes and promotes just the opposite, anticipating nearly doubling the number of oil wells in Kern County in the next 20 years. I know it's not popular in Kern County to suggest transitioning away from oil, But there are several compelling reasons to do so. First of all, global warming and climate change, probably the defining issue for our species. Are we so short-sighted that we'll continue to expand business as usual, burning more and more fossil fuels, overheating our one and only planet, leading to massive disruptions both environmentally and socially? We should be concerned about future generations. Future generations will not look at us at all favorably if we leave them a harsh existence in an overheated world. This project and this EIR makes it easy for the oil industry to get their new wells rubber stamped, makes it easy for oil companies to ramp up profits, operating in secret the way they've done the past 100 years. If we care at all about our planet, if we care at all about future generations, we should be working out methods and incentives for the oil industry itself to transition to sustainable energy production, transitioning away from the unworkable future that this project implies. Don't approve this project. For the sake of future generations, send it back to the planners to come up with something that realistically addresses a viable future. Thank you.
Thank you, Mr. Knipp.
Hello, my name is Victoria Golden, and I am against this project. The project fails to comply with CEQA. The project EIR has not presented a sufficient analysis to consider the environment consequences in the following areas. It talks nothing about seismic activity, and they have had proof in back east where the seismic activity has grown from fracking and injecting wells. You add in the dam that we have and the water changes, and that's going to increase our risk for extra seismic activity. The EIR does not impact the housing. When North Dakota had a lack of oil-filled housing, it led to housing costs and rent skyrocketing due to its related development, forcing renters to pay up and stay. It fails to evaluate and address the disproportion, environmental, and health-related citizen and adequate address safety concerns. And this is for the Hispanic community, and I know that a lot are here today, and the oil wells are really affecting the health and the environment. You talk to some of them, and it really is. I have 7 autoimmune diseases. My father worked in Marathon Oil. I am from Kern County, and I know that this is the way we do things. It establishes a CU process rather than requires a variance process to allow adopting mitigation, to modify, and to delete. This has been, to read this, they have changed the wording, the documentation for the Plan Commission hearing, and it undermines the intent and the mitigation measures circulating the draft EIR report. This should be recirculated. And I've talked to many people in the crowd, and they could not get the reports when they were trying to look up all the information, and the libraries didn't contain also the information. And it fails to mitigate the aesthetics impact from the oil field development with revegetation, remediation, restoration, and other resources and simple methods that could be implemented to help that out. This paper has many complaints, but this is unsafe for our health, and it's just basically letting them run wild with it. Right now, we've had 7 senators that signed that 50% of our oil should stay in the ground, which is Senator Boxer, Bernie Sanders, and Elizabeth Warren are some of the that are listed. And we're going forward with this. In Paris, they're going to do the climate change that's meeting in a while, hopefully to block fracking, but we're trying to rush this through real quick. This whole process, it just isn't fair, and it's not safe for the people of this town. And I live here. Thank you.
Thank you, Ms. Golden.
Okay, Chairman and board members, my name is Tom Franz from Shafter. I'm a farmer and also head of a group called the Association of Irritated Residents, which has been around for about 15 years now, advocating for environmental health for the San Joaquin Valley. But I'm a farmer right now. I'm a retired school teacher. I've always been associated with farming. My great-grandfather, both grandfathers, farmed just a couple miles from where I live and farm currently. And there's a couple generations after me living on the same farmland right now. Farmers are true environmentalists. They're outside, they're aware of the climate and rain, and the rain and water supply, certainly. They're aware of the temperature, the soil quality, and of course the air and water quality. It's very important to farming, and we're aware of that every day as we're outside working our fields. To say that the farmers did a late hit document dump on the county, that's ridiculous. The oil company's been dumping now on farmers in the Wasco and Shafter area in a ridiculous manner for the last dozen years. And that's the place in the Wasco Shafter area where the true fracking is going on that you could compare to other parts of the nation, where they're drilling 8,000-foot deep wells that go horizontally a couple miles. And they're fracking at extremely high pressures with, tons of sand and hundreds of thousands of gallons of water. It's taken 1 million gallons of water just to drill some of those wells. Now, what I've observed, because my property is a couple miles to the west of where some of this fracking and oil drilling is going on prime farmland currently. What I'm concerned about is if the groundwater gets contaminated just to the east of me, it's moving my way. That's where my groundwater comes from the Sierras. Anything that happens to the east of me concerns me because that's my groundwater source. It should concern everyone, what happens as that water flows underground to replenish our dynamic aquifer. So I have some real concerns. I had friends living much closer to some of these oil wells, 2 families that were good friends of mine on Merced Avenue north of Shafter. They complained incessantly to the oil company itself about what was going on in their backyards. They were sick all the time. The oil company finally bought their homes from them, bought them out at a good price to get rid of them. They were living on family farmland. They left, and the oil company gave the homes to the fire department to practice on, so they immediately destroyed both these homes. In between these 2 homes are 2 farm worker families in real low-income type housing. They're still there, and they haven't been complaining, partly, it's just more difficult for them. But there's a lot to complain about, from the air quality issues and so on. Lorelei mentioned that we don't produce gas in this county, it's oil. So tell me why, for the last 3 months, a half-mile north of the elementary school in Shafter, 1 to 2 million cubic feet of natural gas has been flared every day for the last 3 months. They are producing gas, but there's not, it's not worth much. So when they don't have a buyer for it, our air district allows them to use that economic excuse to flare the gas. Most people who can't sell their product have to shut down for a while. Now, that's raising the ozone levels in Shafter all summer long, the flaring of that gas, without a doubt, because of the NOx emissions. And you can actually, well, we can't prove it, but you can see the 1 to 2% increase in ozone levels that, compared to other monitors, when you track everything, when that flaring goes on. It's a direct impact on our health. The county could have been much more aggressive. You stated other counties are more aggressive, like on enforcing idle well stuff. Kern County is choosing with this document not to go beyond anything the state or the Regional Water Board or the Air District does. But you could do that. You have the right to go beyond state agencies in protecting your residents. This document doesn't do that. It's status quo. And we know that Dogger and the Regional Water Board and the Air District do not protect us very well, because of the conditions we have. And groundwater has been contaminated in this county. Dozens of injection wells have recently been shut down because Dogger finally took a good hard look at them in the Regional Water Board and said, these are illegal, these are harming groundwater. The oil companies do, I don't blame them, I guess, they do what they need to do to make a profit. And the county needs to be more proactive. We're better off without this document at this time. Please do not approve it.
Thank you, Mr. France. Who'll be next? By the way, we have about 3 or 4 seats available in the front row.
My name's Trudy Douglas. I'm born and raised in Bakersfield and have many, many family members who are farmers. You've made a change in Volume 5 of the EIR to having cameras replace the 24/7 on-site inspectors in split states. This clause removes all bargaining power from the landowner. It takes away their only protection. If cameras are to be used, they should be backed up with sound level monitoring, and there should also be a downwind monitoring of particulates and chemical emissions. All of this equipment should be in tamper-proof containers. There should also be an alarm system that will inform on-site and inspector personnel of violations. The people who pay the taxes on these lands need protection, and the cameras take away anything in the way of power for them to get some mitigation. It's not fair. Thank you.
Thank you, Ms. Douglas.
Good morning, Supervisors. Heather Minner with Shoot Mahali and Weinberger. I'm here making comments on behalf of Pacific Ag Management and King and Gardner Farms. We've submitted several comments to you throughout this administrative process, but this morning I wanted to focus on inadequate setbacks and proposed changes to the second pathway in the zoning ordinance for split estate lands. Section 1998-060 of the proposed zoning ordinance establishes a well setback of just 210 feet from people's homes. The EIR imposes additional setbacks of up to just 367 feet as air quality mitigation for public health impacts. We have submitted expert reviews concluding that there will be significant noise and public health impacts at those distances, and we request that the board increase those setbacks to at least 1,000 feet. I hope there is no doubt about the board's authority and ability to increase the 210 setback in the zoning ordinance. The board is not bound by the recommendations in the EIR, but can make its own determinations about what is necessary to reduce the project's impacts. Moreover, establishing setbacks in the zoning ordinance is a legislative action. The applicable legal standard is simply requires the zoning regulations to be rationally related to a legitimate government interest. This includes public welfare, quality of life, and community character. The setbacks in your zoning ordinance do not need to be based on scientific reports. They can be based on your own reasoned judgment that people should not be required to live within 200 to 300 feet of an active oil well. Courts repeatedly recognize that zoning regulations necessarily involve line drawing. You have to draw the line somewhere. And where reasonable minds can differ about where to draw the line, courts defer to the legislative body because these are essentially policy decisions. Regardless, our noise expert has recommended at least 1,000-foot setback, and health studies based on an updated OEHA guideline released after the DIR was published finds that 1,800 feet is required. We urge you to increase the minimum setbacks in the zoning code. And I would like to remind you that the proposed ordinance does include a waiver process if some project truly could not meet those setbacks. We are also asking the board to modify the second pathway on split estate lands to require that if there's no surface owner signature, a conditional use process is required with the same 120-day timeline to allow for continued negotiations between the surface owner and the mineral rights owner. This EIR analyzes project impacts at a very generalized level. It's simply looking at how the project may affect regions in general that cover thousands of square miles. There has been no site-specific analysis of impacts to particular farms or particular water sources. What we are asking for is an opportunity for meaningful engagement with the surface owner to be required, not just hoped for. Under the current process, there is no opportunity for the landowner to express concerns about the proposed site plan and timing of operations. And there is no opportunity for the county to respond and require additional site-specific mitigation measures as a result. Yes, the current process includes a meeting with staff, but this is a one-way conversation to explain the process and mitigation measures. There's no ability to modify the mitigation measures based on on-the-ground conditions. The CUP process would provide for a public forum for landowners to give information and to express their concerns, and more importantly, allow the county to impose conditions tailored to the specific wells being proposed on a specific farm. In its response to this proposal, the staff notes that there could still be over 100 CUP applications on split estate lands each year. But I do not believe this board declines to address problems because they are too widespread. The county can recover its administrative costs when processing permits, and if it must hire additional staff, so be it. A signature or CUP requirement is still a streamlined procedure for oil and gas permitting because the county could rely on the analysis and mitigation measures in this EIR and tier off of that. Modifying the second pathway to require a CUP on split estate lands with a minimum of 100-day processing timeline will go a long way to reducing the significant land use and agricultural impacts of this project, which were concluded to be significant in the EIR. If the board does not wish to require a CUP, we are asking that the board at least require applicants to make a good faith effort to negotiate an access agreement with the surface owner. BLM regulations include this requirement for federal mineral leases, and the legality of doing so is clearly established. In its addendum staff report, staff complains that a good faith effort is not a clear standard, but this is a common legal term, and the county has many smart lawyers and staff working for it that can delineate this requirement. I'm handing the board two additional documents. One is a summary of conclusions by our air quality expert. The other is a history of Kern's amendments to its zoning code, which shows that the county rarely makes substantive updates to its oil and gas ordinance, and your decisions today will impact the residents for decades to come. I'd also like to assure you that our air quality expert was working as quickly as possible to complete her report and review of this highly technical and detailed document. Her comments were not submitted with the DEIR because much of the information that is usually included in an EIR was not included in the DEIR. We had to submit Public Records Act requests for this information. The county delayed in giving us the documents. A key part of the air quality analysis, the cumulative public health risks impact assessment, was just provided to us last Monday, 5 business days before this hearing. So it's not a big surprise we weren't able to get our air quality expert comments in time. If you need additional time to review them, please do so, but I'm handing you a summary of her conclusions here. Thank you very much.
Thank you. Could you tell us your last name again?
Heather Minner, M-I-N-N-E-R.
Thank you. Who'll be next?
Hello, I'm Chris Romanini. We farm under John Romanini and Sons, R-O-M-A-N-I-N-I. We have orchards in the Rosedale area with long-term idle wells. I submitted comments with photos showing our derelict equipment, some idle nearly 30 years. I get it. This structure is not intended to deal with old legacy wells, but I don't see that the new ordinance has fixed the problems going forward. The right way to mitigate the loss of farmland for every new well on farmland is to give idle well land back to the farmer on a one-to-one basis. But the county lets the oil companies choose between 4 choices with what mitigation it wants, like purchasing a conservation easement. Then the oil companies does not have to remove their old rusting tanks, their idle wells, or clean up the contaminated soil. What would motivate the oil company to restore my land when it is cheaper and easier to buy an easement? That your mitigation 4.2-1 gives them these choices, but it must go. You must not give 4 choices. You must require abandonment on a one-to-one basis to control accumulating more idle wells on farmland. You know, the sequel requirement is that all feasible measures be taken to mitigate the loss of farmland. Idle wells removed on a one-to-one basis for every new well will result in no net loss to farmland. Requiring this will allow the supervisors to say they have done everything they can do because they are requiring no net loss. But a conservation easement doesn't do that, and it doesn't give me my land back. In our case, most of the idle wells on our property are in bankruptcy, like for 5 years I'm aware of. The neglect is obvious. Dogger tells me that no testing for leaks or contamination is occurring. I have requests with Dogger that have gone on for years, and they are now with the legal department in Sacramento or wherever it is for over 2 years. All I'm doing is asking for inspections. The environmental issues can be enormous, and I can foresee that I may be the one required to clean up their mess. I suggested a bond on all split estates to ensure that funds are available for maintenance and abandonment. The EIR simply noted my comments and nothing more, so I'm petitioning you. Please consider real financial structure, a bond that will finance protections before you move forward. The EIR states that oil activity on farmland is temporary and that farmland can be farmed again in the future. Really? Where's that structure? How about a time frame that absolutely gives our land back in, say, 10 years or 15 at the most? Stop right now and address what still needs fixing, or I can see a vast number of future idle wells looking just like mine on my farm, also resting on farmland for 30 years or indefinitely, but you have a chance today to do something. I hope you do. Thank you.
Thank you, Ms. Romanini.
Good morning. My name is Jenny Holteren, and I am a farmer in the Wasco area and a concerned member of the agriculture industry. I belong to a 5th-generation farming family in which 3 generations are active in the day-to-day dealings. It is the family farm that has built the agriculture industry, and we deserve better treatment when operating on split estate property. Over the past 15 years, my family farm has lost 6 acres of established trees due to drilling oil wells on our property on 4 different sites. On our property, there are oil wells that are in production, that have had no production in at least 2 years, and 1 well that is in the process of being converted to a water disposal. The most recent oil site was placed in the middle of a 160-acre block to our opposition. We had requested input to the location of the site, and our contribution was not considered. It would have helped our farm tremendously if service owner involvement had been required to proceed with their site plan. The drill sites on our property are elevated above field grade, a construction that was also not approved by us, the surface owner. These drill sites allow runoff, spillage, and contamination to flow off-site and into our fields. Another situation that a surface owner involvement being required could have avoided these land use issues. Our surface, trees, and crop have been damaged by oil operations on our farm. One such instance required the destruction of part of our almond crop due to oil spill and overspray. These unnecessary, costly, and detrimental situations have harmed our surface and farming capabilities. Our farming involvement and surface ownership have not damaged the mineral owners' minerals or their capabilities of access. It is with this that I ask you to supplement all surface access agreement pathways to require the mineral owner to certify that an agreement with the surface owner has been reached. If a surface access agreement is not reached, then potential loss and damages must be reimbursed at minimum. If no surface owner signature is obtained on the site plan, a conditional use permit shall be required. It would ensure agricultural land be given just consideration, as other land issues require conditional use permits already be conducted in such instances. I also urge you to consider a 60-day notice versus the 30-day notice to negotiate any amendments to the site plan prior to the final plan being submitted to the county. The amendments negotiation being settled prior to final plan submittal is imperative to a family farm. Allowing 60 days will provide ample time to mitigate the ramifications of oil drilling on proposed sites and help to eliminate more problems from occurring in the future. Please consider the implementation of these surface owner agreements to ensure that family farms are able to thrive and contribute to the prosperity of our county. Thank you.
Thank you.
Hi, I'm Holly King. You all know who I am, I'm sure. And I am here representing the Committee to Protect Farmland and Clean Water. There are 65 farms in this organization representing 225,000 acres. I myself am a fourth-generation farmer. I didn't dress like one today, but I'm in town. I wanted to talk about the EIR, obviously. Staff is asking you to certify this EIR with overriding circumstances in 8 of the 18 categories on the CEQA checklist. So essentially, half of the categories will have significant impacts that they indicate they cannot mitigate by stating that, and I quote out of the EIR, such impacts are at an acceptable level in light of the social, legal, economic, environmental, technological, and other project benefits discussed below, and such benefits override and outweigh and make acceptable any such remaining environmental impacts of the project, end of quote. The categories that were in this list where there's overriding concerns or considerations are air quality, ag land loss, greenhouse gases, water hydrology, both supply and quality, utilities and service systems, cultural, biological, and aesthetics. So let me ask, are we all okay, or are you okay with deterioration in all of these categories because we can't adequately mitigate? Short term, we will have jobs, but if one will venture out into the future, maybe not. Who will live here with water we can't drink or irrigate with, or air we can't breathe? Will the city of Bakersfield somehow be shielded from all these impacts and have its own little bubble to sit under and be safe? The Board of Supervisors has an obligation under CEQA to implement every possible way to reduce impacts. We have for you a method to reduce farmland loss that is being overlooked. Chris Romanini described it. It's versus the 50% loss of farmland with the conservation easements, that an acre for a new well be offset with taking out an idle well acre. That is no net loss of farmland. And I would encourage staff and all of you to take this proposal out from under the legacy heading. This is about restoring resources. It is done all the time where there's a loss of a resource in one location and it's restored in another. An example is wetlands. If you destroy a wetlands, you can create a wetlands in another location. Habitat's another example, where it's destroyed in one place, you create it in another. One other thing that I wanted to touch on is the traffic mitigation fees. Since the Planning Commission hearing, this has been changed along with other things. And in that, if the traffic mitigation fees, if there is a local ordinance passed, then the mitigation traffic impact fees would not have to be paid by the oil companies. This is challenging to me because I believe that any loopholes allowing the industry to escape from paying the mitigation fees they've agreed to if alternate sources of funding from taxpayers or other development becomes available should be eliminated. We don't want to impose costs on the oil industry, but we also don't want to allow the oil industry to pass on their costs to the taxpayers or others doing business in Kern County. Thank you very much.
Thank you, Ms. King.
I'm Eva Nip, retired high school teacher. I hope I taught my students cause and effect. That burning fossil fuels has the effect of global warming and air pollution. Also, I hope I taught my students the value of making decisions for the long term, not just short-term gratification, such as profit making. We need to transition to sustainable, clean energies for the benefit of their survival. We don't need thousands more new oil wells. What we really need is solar panels on every parking lot, on every building. I oppose this project. Thank you.
Thank you, Ms. Nip.
Hello, thank you for the opportunity to comment. My name is Marian Vargas. I am a retired elementary school counselor, and I too am a stakeholder. And I think we need to remember that we who live in Kern County are all stakeholders. I am here to oppose the provisions that are being presented to you today. There's been lots of interest. I know that oil is a huge economic force in our county. I know that, most of us drove here in cars that perhaps were not electric, and there are lots of other reasons to appreciate the benefits of the petroleum industry. However, I am concerned about the fast tracking of development because of the consequences that there are that come with petroleum production. And I am concerned that there are stones that have not been turned over. There are things that we could do that perhaps that the Board of Supervisors could direct the Planning Department to advocate on behalf of the stakeholders, those of us who live in Kern County, to advocate more that current regulations be enforced, that places that are polluted, like the Elk Hills oil fields that have not been cleaned up for so long, that condition exposing oil field workers to cancer-causing pollutants. That's just one example. There's lots more that could be done, and I'm afraid that if we fast-track such a huge increase of oil production for our county for 25 years that the impacts will be very serious. Now, in reviewing the information that came out, the addendums to the agenda, et cetera, I thought, wow, this is so much information. And you have a really well-qualified planning department staff. There are all these experts. And it must be really hard given what you as supervisors have to deal with and to consider. And I'm asking that today that you give very serious consideration to the more specific comments from others who have opposed your passing this, this whatever it is today, this project today, because I mean, the impact of your decision today is huge, and if you could have the courage to take a little more time to consider those, the impacts and the questions that are being raised, I just, as one of your stakeholders, would appreciate that. And, you know, we're not dumping, I don't think people who oppose this are trying to litigate for the fun of litigation. It's because people have real concerns. Have you never had problem breathing on a really polluted day? Have you looked down the street and not been able to see down the street? Or have you ever wondered if the mountains are really there when you can't see them from Bakersfield? I know some of our pollution has to do with our geography, but a lot has to do with the pollution that industry and everyday people produce, and we need to turn our attentions to enforcing the regulations that we have, and then also being very creative, put some of those energies that you have to be creative in coming up with ways to make a better environment for us, and that is so that we can be healthy and continue to live here and not feel like we need to leave Kern County. So anyway, thanks for listening to my rambling.
Thank you. We have about 5 or 6 seats now down front. Yes, ma'am.
My name is Mary Lynn Briggs. I live and work here in Kern County. I'm a registered nurse. I've been a nurse for going on 24 years. I work in the ICU. During the years I've worked in the ICU, I have seen more people with more respiratory diseases, sicker, and the ages of those patients that we see are getting younger and younger. The effects of oil production, fracking on the quality of our air is increasing. 2 months ago, I went on a tour of some of the oil production sites, some of the fracking sites in the county, and I was really amazed at how close those wells and those fracking sites are to schools, elementary schools, public gardens, right next to a public garden, how close it is to land where the food that I eat is grown. There's not enough regulation of the chemicals that they're used in fracking. It's in my mind, it's kind of similar to me going to one of my patients saying, well, I have these drugs, and I think that this drug is what's best for you because I have it, and that's what I know. Now, I can't do that. Why can the oil companies do that? We have so many days with so much air pollution that children, elderly people, people with respiratory issues are told not to go outside. We need to take into account the impact, the oil production, the oil companies, the gas burn-offs, that impact on the air that we breathe. I am a voter here in Kern County, and I may have one vote, but there are other people in this county who vote as well, who look at the issues thoughtfully and carefully. We do not have the money that the oil companies have to put into support of regulations that will help our bottom line. Please consider the people who vote here in Kern County, the people who voted for you. Thank you.
Thank you, Ms. Briggs.
Hi, I'm Wendy Laughlin, and I would like to urge you to use your legislative authority to do something at this critical moment in our future. We have air problems here. We're setting an example here as one of the highest areas of petroleum type of exploration to make a stand for our environment. And water is sacred. These are the things that get affected when we go with a lack of regulation all the time that we did here in California, where all these unpermitted things went on between Jerry Brown maybe getting donations from industries. I don't know what future plans any of you have, but I'd love to know, because I think that it should be more important that we protect our air, our land, and our water. And I'm just asking you to be not destroyers, but creators, because we are at a desperate moment where we have not done anything concrete toward making agreements with the rest of the world over our carbon usage, and we can see that it's desperation time, and we need to act in that tenor, in that tone of understanding where we are in history and how history is going to judge what you do here, and your progeny are going to judge that also. And we here will judge you as well. And I hope that you will think about the future and not, some niggling little regulation, that you will think about the actual long-term effects. And no, you can't always recreate your habitats that you destroy. You cannot always create a new watershed when you destroy it. You have got to think of the whole picture, and we have got to do better, because we're not doing good enough. We're not doing near good enough. And you need to be part of this change that needs to happen. Sorry for your little, whatever those looks are supposed to be, but we can't just rubber stamp it all the time. Can't go on the way we've been going. This is the crossroads here. So I would ask you to consider that. Thank you.
Thank you, Ms. Laughlin. Who'll be next?
My name is David Campbell. Campbell as in the famous red and white canned soups. And you'll be happy to know I don't have any documents to present to you. And I have a very simple point and plan to be sitting down by the time the 53 counts down to 0. My concern is that we have had serious lack of rainfall for several years. There's great concern about the snowpack. There was much justifiable wringing of hands about that last spring. Looks like it may happen again. The ocean is acidifying. The kinds of shellfish that you and I like to enjoy are having a more difficult time trying to reproduce and, in fact, to reach maturity because they can't fix calcium. Islands in the oceans around the world that are low-lying are facing rising sea levels. The experience of some of the Aleutian Islands in Alaska has been documented pretty well, and South Pacific Islands as well. Low-lying countries like Bangladesh, who are barely above sea level, a few inches or certainly a few feet change in ocean elevation affects them deeply. How does that affect us? We have 58,000 oil wells, which is more than I realized that we're in production. We are adding to the level of carbon dioxide in the Earth's atmosphere. Over the last 12 or 13 years, every single year, the worldwide temperature has gone up. And that's got to do with the amount of carbon dioxide in the atmosphere. We're proposing to make it easier to generate more oil production, we're also making it easier to generate more carbon dioxide production. I hope that we keep the big picture in mind, not only the long-term, but the widespread physical effects of this oil production, and that the resources, that many of the resources that are being used to increase production could be used to explore and develop other sources of energy, which of course we need. Thank you.
Thank you, Mr. Campbell.
Good afternoon. Buenos días. Mi nombre es Gustavo Aguirre Jr. Good morning. My name is Gustavo Aguirre Jr., Chairman, Board of Supervisors and staff. I'm here representing Central California Environmental Justice Network. I'm the project coordinator for Kern, the Kern Environmental Enforcement Network, a working task force here in the Central California Valley that have stakeholders from community members, nonprofit organizations, non-government organizations, and regulatory agencies, including the Air District, Environmental Health, and DOGGR recently. I'm here today in front of you to first and foremost correct a numerical error that was mentioned earlier. There was mention of 800 petitions that were signed. I'm sure all you supervisors received more than that electronically and in written format. I have here more than 2,600 signatures that have been signed. You all have received it, I know that, because I personally sent some out. And first and foremost, I want to get that out of the way. Secondly is the disasters that have happened around oil and gas in the industry here in the Central Valley. One example that I could use is the Arvin pipeline leak, how government agencies and regulatory agencies dropped the ball on one simple project and failed to protect community organizations and community groups. How are you going to do that with, rubber stamping and fast tracking for the next 25 years, 60,000 new projects, if the old infrastructure that is existing now is failing and so close to government, so close to residential properties, so close to places where community members congregate, churches, hospitals, schools. So we're here today to make sure that first and foremost these petitions are received to all your staff, and that you do not certify the final EIR draft, and consider the probability here in the future of the damages that could occur from this. Thank you.
I'm sorry, could you give us your last name again and spell it for the record?
Aguirre.
Thank you.
Sure.
Yes, ma'am.
Good morning. My name is Dr. Rosana Esparza. I'm a gerontologist, and I'm also an organizer for Clean Water Action, or a not-for-profit organization with members throughout the United States. What I really want to talk to you about and to bring to light is the fact that many of our frontline communities are impacted and affected by what decisions are made here. I specifically work on the western edge of Kern County, Lost Hills, Elk Hills, Buttonwillow. And what I see every day when I go out is I see people who are suffering many, many different types of health effects. I've never been in a community where I've seen so many children born with spina bifida, nor have I seen as many community members, women in particular, who are suffering with different thyroid cancers. And I'm wondering, why? Why is this happening? Why is it happening here? This is a community that has always supported its people. It's a community that's always pulled together. And that was one of the reasons why I wanted to come to Kern County and be a part of your community, because of all the promise that it holds for future, and because you have an opportunity here to really grow your population and do the right thing. In my work in Lost Hills and seeing patients, seeing people that are affected, health effects and impacts of oil and gas production, there's also issues associated with agriculture. We also control for your transportation, diesel fuel, individuals traveling Highway 46 on their way out to the coast, Interstate 5 coming right through. All of that has an impact on the lives of people who work and produce some of the largest amounts of nuts, almonds, pistachios in the world. What do you do without this population? What happens when they start getting sick? We're looking at the cumulative effects over time. These are people that are your neighbors, or our friends, or maybe not particularly your neighbors, but they are my neighbors, and they are my friends. And I wonder, what do we do for them? Do we come here and come before you and ask on their behalf and petition you to say, please, we can't legislate morality. That's been proven over and over again. It's not possible. But we can ask you to think with your heart, think with your mind, and make decisions based on what you see and what you want your future of your community to be like. I understand the challenges that you have in this community, and they're very complex. No one is asking for anyone to lose their jobs. We all need to be employed. We all need to feel that we're a part of our community. But I have to ask you to open your heart, think clearly about what we're asking for before you. We don't want to suffer from some of the most grave impacts and effects of arthritis, asthma, chronic obstructive pulmonary disease, hyperthyroidism, thyroid cancer, Parkinson's. How do you feel thinking that Kern County is known as Parkinson's Alley? As a gerontologist, I look at what happens to people as they age over a lifetime. If you've lived here for more than 25 years, chances are your lifespan is going to be declining by at least 12 in comparison to other counties. Do you want that for yourself? And moreover, do you want that for your children? So that you can expect your grandchildren will be gone by the ripe age of 45. I don't think any of us want that. What I'm asking today is for you to think clearly, confidently, and know that there are those of us in the community who do speak for ourselves as well as for our friends that aren't here today. And we're asking you and we're petitioning you to be responsible and do the right thing. We've said what we have to say, and now I'm just going to ask for everyone who is in solidarity with what we are saying to please stand. And take a moment, and I ask you to please consider what we're asking and make the right decision. Thank you.
Thank you, Doctor. We have a few seats in the front row.
Hello, my name is Sharon Briel, and I live in Bakersfield. I'm relatively new to Bakersfield. I've only lived here for about 15 years. And I want to speak to you about the complexity of the issue that you have in front of you. I appreciate that you discussed that you had 7 public meetings, but I have to believe that the degree of scientific knowledge and background in oil and various other aspects of government regulation was far over my head. Yet I have a college education. I'm very fortunate in that degree. But I started to read it and I said to myself, I can't make any sense out of this. I really believe that when you're going to address something this complex, you must bring in more opinions, more time, more commenting. You have to educate us citizens on what you're about to do because it affects me and my neighbors and my world. So I really think that more time and effort has to be made to make these complex situations much more understandable for the general public. Having worked for a school district and realized that the average citizen does not have time to even attend school board meetings that affect their children, you can believe that probably not as many people as we should have had showed up at these 7 public hearings. I just think it shows a great lack of including the public and educating the public so that we can stand behind you if you're going to make a decision and we truly understand what you're about to decide. Being new to Bakersfield, I have to comment that I'm very concerned about the reputation of our county. I came from outside of the county, and I have to tell you that when I went to the post office to turn in my card to say I was moving, my postman asked me why I was moving here. He didn't understand why anyone would want to come here. And when I got here, I was very pleased. I liked seeing the agriculture. It's a very diverse and interesting place to live. And I was very, very appreciative of the community spirit that we have here. I never saw as much emphasis on helping others with fan drives and being aware of the local sports. It is very, very unique. But I'm very, very fearful because we don't have a good reputation. This morning in today's news that I caught briefly as I went out the door, Wasco and Delano on the lowest list for places to live. This is not good, and I hope that you would keep this in mind in your decision, that you want people to come and live here and be happy. Lastly, I just want to say that I am fearful for my safety. I had an opportunity at a recent meeting to see a FLIR camera. Being new to this area and being totally unaware of gas and oil, I was used to be very pleased when I'd go over the big overpass going to Lowe's and seeing the flare. I thought, wow, isn't that interesting? I didn't realize that flare, if viewed with a FLIR camera, which takes in pictures that you cannot see, showed off an extreme amount of emissions, which I don't believe will be covered by your 200-foot easement away from schools and such. So I don't feel safe. I'm asking you to oppose this project and give it more time for more consideration. Thank you.
Thank you. Who'll be next?
Hi, I'm Catherine King. I live in Pine Mountain Club. I'm also a member of the Tri-County Watchdogs. I fear, especially after listening to all these comments today and having read as much of the documentation as I had time to do, including many of the comments, I fear that the Board of Supervisors is on the verge once again of putting itself on the wrong side of history, just as it did in 1939 when 4 supervisors voted to ban the grapes of wrath from county libraries and schools. That vote attempted to help growers by hiding the truth about farm labor conditions from the public. You will join that board in infamy if you vote for this zoning change, which attempts to boost petroleum profits by hiding the truth about toxic air and water conditions from the public. Last night on CBS News, I watched an interview with Bakersfield mother Kelly Ryan, whose primary immunodeficiency disorder took 2 years to diagnose. Why did it take 2 years? Well, she explained, it seemed normal to get sick in Bakersfield. If you approve this zoning change, I fear that it will be more and more normal to get sick throughout Kern County, where the setback for wells is only 210 feet from residences, schools, and hospitals. And I very much appreciated hearing from the gerontologist about what she has personally observed in terms of this sickness. Not only will chemicals from injection wells seep into aquifers and soil, but traces of them in what is called produced water will be deliberately poured onto crops for irrigation, sprayed onto fields for dust control. Gas leaks, like the one that happened recently in Arvin, will pollute the air we breathe. The final EIR and the planning department poo-poo the CBD's, the Center for Biological Diversity's concern about this issue, claiming that emissions are low enough not to cause health concerns. However, I have seen documentaries where folks near fracking operations suffer horrible headaches as well as increased illness. And we had just heard an example of a doctor, a gerontologist, who's seen much of this. It is not yet clear what damage lots of little leaks and emissions can do. Until we know more, environmental impact reports that take into account the latest research should always be required for every new permit, and that should be, as has been said before here, site-specific. Although they refuse to acknowledge important threats to health, the final EIR and the Planning Department do recognize in Exhibit C the significantly smelly ugliness that comes from increased drilling and fracking. They recognize the significantly increased air pollution, loss of farmland and forest, destruction of biological resources and paleontological treasures. They recognize the significant diminution of water quality and quantity. They even, astonishing to say in a Republican county, they even recognize a significant impact on climate change. All these hazards, they admit, are unavoidable. Contrary to the subsequent claims of Exhibit C, that is, overriding considerations, these are not acceptable hazards. I ask the Board of Supervisors not to put us all at risk by certifying that they are acceptable. I ask the Board of Supervisors instead to opt for health and the right side of history.
Thank you, Ms. King.
Good morning, Chairman Couch and Board. My name is Ann Gallon. That's gallon like a gallon of gas or milk. Some of you know my history that I have a stepson, late stepson, who was an environmentalist. So environmentalism is a discussion around our dinner table and has been for 30 years. He was Canada's Environmentalist of the Year in the early 70s, and a big concern of his then was oil leaks and oil disasters. He went on to work with the government of Canada, and they worked on the problem of the acid rain and had to sue our EPA for not enforcing their own regulations. We see here in Kern County there are problems where Dogger has not been enforcing their regulations. We see open pits, and water has not been, the produced water has been not contained properly. And I know some of you are under pressure from people who think big government is bad, but a part of government is having enough people to go out and investigate what's going on and investigate problems when people call in. Even the sheriff department now can't go out to every problem, and they have to have people just file reports online. But we have some major problems within the environmental industry, and fossil fuels present a major problem around the world. The oil business has lots of money. They spend a lot of money on lobbying, millions on lobbying, and they also have well-trained lawyers. But we've also been learning, as I heard long ago about environmental global warming, the industry has known about climate change and global warming for 30 years also. Some years ago, another group in this town made a vote. They voted on Highway 58, and they decided to stop Highway 58 at the Wild West Shopping Center. That was a group of people, the city council, who did not foresee 10, 20, 30 years in the future, and we're still dealing with the fallout from that vote. And you each have a vote here today. And I hope you will consider that climate change is a huge issue. It's going to affect all of us. My 3 stepchildren have died already. 2 from cancer and 1 from pulmonary disease. And we need, please consider the health, the public health that you are voted to preserve when you make your vote today. And you know that I do oppose approving this streamlined gas proposal by the oil industry. Thank you for your consideration.
Thank you, Ms. Gowan.
Good morning. I'm sure you're bored with all this. You're champing at the bit to get on with it and vote. I don't blame you. This must be tedious. You must have been besieged by comments pro and con ever since this began. I live up in Pine Mountain in Mr. Couch's district, and I have the advantage of clean air. And I don't see oil derricks bobbing up there, but I fear for the people who live down here. I get to the top of the hill, and I take a deep breath and try not to breathe when I'm in Bakersfield. I don't think this is good. I ask you to consider the people when you're gone. The people who don't have jobs in the oil industry any longer because they're dead and gone. And I just fear that the public is going to be picking up the tab for generations to come on a vote that you may make today. I ask you, please reconsider. Thank you.
I'm sorry, could you give us your name, please?
I just remembered. It's Mar Preston.
Thank you.
M-A-R is my first name. Thank you.
Thank you.
Good morning, Chairman Couch and members of the board. My name is Todd Turley. I'm with South Valley Farms, which is a local farm growing almonds and pistachios, and we are one of those interests that have a split estate scenario. I first want to state that I am not speaking in opposition to the project as a whole. We believe that both the ag industry and oil industry are critical to having the economy of Kern County thrive. However, this is a project that will govern operations and interactions between the oil industry and ag industry over the next 25 years. With that in mind, I suggest that there are refinements needed to the project as proposed to the board. Specifically, I have 3 comments. First, representations have been made by staff in their staff report and EIR and to the ag industry to minimize the potential impact to ag land primarily located in Tier 2. Staff estimates that of the total annual permits anticipated, I believe 1,800 to 2,000 permits, approximately 230 are expected to occur within Tier 2, and of those 230 permits, 30 are estimated to occur within split estate scenarios. However, these are only estimates, and there is nothing in the EIR to legally limit the number of permits in Tier 2 to 230 permits per year. Since these numbers are being used to pacify ag interests, we ask that the board set a hard cap of 230 annual permits within Tier 2 over the life of this project. Second, I would ask that the footnote in the Oil and Gas Conformity Review and Minor Activities Review table be modified. It currently states, ongoing operations of existing wells, facilities, and equipment, including minor modifications such as new interconnections between such facilities, does not trigger conformity review or minor activity review. When these accessory uses, equipment, and facilities are proposed as part of the same project as an activity that requires an oil and gas conformity review, then these accessory activities are required to be included in the oil and gas conformity review. In all other circumstances where new ground disturbance occurs, these accessory activities are subject to minor activity review. Ms. Oviatt presented an example to the board this morning of a scenario of a minor activity. She proposed a scenario where there's an existing oil well that predates this ordinance, and then after adoption of the ordinance, the oil company wants to replace the tank, possibly making the site bigger. Ms. Oviatt further suggested that such an expansion may be covered by the prior agreement for the original oil well, but a surface owner may hold the oil company hostage with the longer permit review process. What was not stated is that the same oil company could abuse the process by representing an expansion is covered by an existing agreement when in fact it is not. Moreover, such a limitation encompassing minor activities tying them to previously existing operations is absent from the footnote and from the ordinance. If Ms. Oviatt's scenario is the concern, then I propose that the minor activities and associated review be limited to scenarios where they occur within an existing operation and are covered by a prior agreement, and that the mineral owner certifies that such is the case, providing the surface owner with a copy of that certification. Furthermore, under the scenario where a minor activity is proposed for an operation covered by a permit under this new ordinance, then it could only proceed under the minor activity review if it occurs within the boundaries and limits of the permit that underwent the conformity review process. If there is new disturbance and proposed outside of those boundaries in a split estate scenario, then it must proceed under a conformity review process. Finally, the inspection requirement has been changed from what was presented to the Planning Commission to allow for on-site camera surveillance to be proposed. The applicant stated that it was supportive of the ordinance as proposed to the Planning Commission and was clear that it would not budge with any additional requirements. However, they felt it fair game to change requirements that would potentially be to their advantage and under a process that was presented to the ag industry as an adequate compromise. We request that this provision be removed and that the inspection compliance provision remain unaltered from how it was presented to the Planning Commission. If the board chooses to keep this option, then we request that the board delay adoption of the ordinance until adequate language can be agreed to with the Kern County Farm Bureau. As it currently reads, it is vague and does not provide adequate guidance for standards, nor does it address the rights of the surface owner that could be impacted by such surveillance, which owner is still the legal owner of the surface. Thank you.
Thank you. Do you have a copy of that, by the way?
Oh.
If not, that's okay. I just.
My comment?
Yes. Thank you. If you don't want to submit it, you don't have to, but it might be helpful. Thank you.
Can I submit it through the...
Sure. Thank you, Mr. Turley.
My name's Linda Robredo. I live in Fraser Park. The first thing I need to do is forgive you for if you've arrived here with a predetermined which way you're going to vote, that if you vote in that direction, I already forgive you. I understand this is jobs. I understand this is Kern County, and I understand that a lot of Kern County's industry is based on oil and other industries. I understand that. I also know what I saw when I first drove to Taft, California as a Kern County employee. And then what I observed for the next 4 years is I commuted to Taft, California as an employee at the Career Service Center. I observed and I continue to see dead land. Why is that? I got into the history of Kern County, and it was because of that moment in that movie Armageddon. We hit oil, and the oil blew, and it fouled the earth, and that earth is still dead. That was my first observation. It just came out of my mouth. I said, what happened here? The land's dead. Nothing grows. That happened decades ago. And then while I was there in Taft, California, Randy, another gentleman, he was born and raised in Taft, California, proudly gave me a tour of Taft. I mean, Taft's a nice town. And I asked, what is that area that is chain linked off that's in the middle of Taft? And he said, oh, a few decades ago, the oil company abandoned that land because it's polluted. And I'm thinking, why wasn't it cleaned up? This is in the middle of Taft. It's still there. The reason why I'm saying this is because currently there are 11 injection wells that have foul drinking water in California, and the state has in the EPA. I've noticed it. The state became aware of that in the last couple of years, and they're now going in the direction of reviewing all of the aquifers and potential pollution. I'm really highly concerned, given the track record of the oil company. You know, whatever happens today may affect us in the future and it not be cleaned up. My concern is our clean water. My concern is mistakes. And when I read, hours and hours of documents deep into the night, what really jumped out of me that no one has spoken about yet is a loophole that I'd like you to consider closing up, and that is allowing the oil industry to transport the wastewater in trucks, and that the oil industry work it out amongst themselves where that wastewater is going to go get dumped. I wish I could trust everyone, but there is human nature of someone running short on money, short on time, short on whatever, and their truck leaving and just emptying off into a field, maybe an ag field, and not be traced. It's very easy to put GPS tracking on every single truck that leaves with wastewater, every single truck. And that it's very easy to legislate while you're doing this that there be severe fines if that truck does not go from point A to point B. That is a pre-arranged area that is approved. And I don't see it in here closing that potential mistake for whatever reason, that there be a body of people to follow that. I am concerned about our environment. I'm concerned about the water. I'm concerned about the agriculture industry, the overall health. I'm sure you are too. And again, I've forgiven you if you've come with, the jobs in your pockets and you must vote one way. I also know that we're at the tipping point. My son, one of my children, he's in college, and he cleared something up for me because I just couldn't get my head wrapped around. Why is this happening? And he said, the tipping point is this, Mom, is that when it is more expensive to frack oil to gain and put it out there than it is to install clean energy systems, that's when fracking will stop. That made sense to me. It's a financial tipping point that we're right now at. And what he also added, and this is what the college professors are suggesting probably, is that tipping point happens right about $40 a barrel of crude. While we're underneath that tipping point, there's very little work that's going to open up in fracking. When we go above it, it's going to go really full on. And that's when these regulations that you're voting on today or considering today will go into a full on, let the oil blow out. So I know there's a lot to concern yourself with. I know that you're doing the best you can to staff it out and hear from your experts. Be very careful. Please be very careful. Thank you.
Thank you. Let's hang on just one moment. It's a little bit after 12, and can I ask to see how many more people are intending to speak in opposition? 1, 2, 3, 4, 5, 6. Are there any hands up in the, is that you, Ryan, in the back? No, it's not. Whoever that is in the back, could you take a look out in the rotunda and see how many people you expect out there? I think we have a count of about 6 in here.
Mine's 60 seconds.
I understand. Okay, if yours is 60 seconds, please come up and do that. I want to remind everyone we're trying to stick to a 5-minute time limit.
I am Lucy Clark. I'm a resident, District 1, and I am here to oppose this proposition because I'm an advocate for children, and I think we're
talking all around with air and health, and I'm a victim with adult onset asthma and COPD from living here. Every doctor has told me that. But children are going to be affected. They are being affected. Their children will be affected as global warming proceeds. And I think this is the real tipping point, is of how can people survive living in this climate as things get worse. Thank you.
Thank you.
Good morning, and thank you for the opportunity to comment today. My name is Sarah Otzbaha, and I'm here on behalf of the Natural Resources Defense Council and our thousands of members and activists who live in Kern County and throughout Southern California to urge the Board of Supervisors to reject this ordinance and not to certify the EIR. The EIR attempts an impossible task by trying to protect Kern County from 20 to 25 years of unknown environmental and public health impacts from future oil and gas development. This doesn't take into account the fact that today we live in uncertain times. Statewide, we're facing challenges like the drought, climate change, air pollution, and poor air quality generally. Knowing this, it's not just wrong, it's dangerous to pretend that the county can protect Kern's residents with the inadequate mitigation measures set forth in the EIR. The county attempts to consider all of this development in one document in order to streamline the administrative process to the benefit of the oil and gas industry. In doing so, we've left the residents of Kern and the environment without adequate safeguards. The final EIR claims that the increased emissions will be addressed with mitigation measures. However, the proposed measures are grossly inadequate to protect the local community. I have two examples. The first is for air quality mitigation. We rely on existing AQMD rules, but we already know that this measure is ineffective based on the current non-attainment standards for the San Joaquin Valley. Similarly, the mitigation measure for the percolation pit use relies on existing permit requirements. However, the final EIR does not address that even permitted percolation pits have the potential to leach toxic chemicals into our precious groundwater. The resulting pollution and environmental degradation will disproportionately burden people of color here in Kern County, and they already shoulder an unfair share of the burden of pollution in this area. Kern County is responsible for over 75% of the oil development in California, and the proposed ordinance seeks to expedite this development while also shielding it from further environmental review. This raises significant environmental justice concerns. Nearly 300,000 people live within a mile of a well here in Kern County, and 76% of those people are people of color. What this means for the local community is that 76% of people are shouldering a disproportionate exposure to industry hazards such as increased air pollution, increased contamination of drinking water, and increased contamination of soil, as well as other risks to public health that we've heard about today. Finally, we'd like to reiterate some of the Sierra Club's points about the county's review process for the ordinance, namely that it did not allow for adequate public participation. The county only gave the public 60 days to review a very large document. I believe the number was 1,800 pages, as well as the 6,000 pages of appendices. An even smaller window of time was provided for review of the final EIR. And we'd also like to bring to your attention that despite the fact that Kern County is home to many Spanish speakers, none of these documents were provided in Spanish. For these reasons and the reasons in our comment letter, we ask the Board of Supervisors to reject the proposed ordinance and not to certify this inadequate substitution for environmental review. Thank you.
Thank you. Could I ask you to spell your last name?
Yes, it's A-T-S-B-A-H-A.
Thank you.
Thanks.
We'll keep taking testimony for a little while longer.
This will be very short.
Thank you.
My name is Dinah Campbell. I'm a longtime resident of Kern County. First of all, I want to express my concern, as many other people have, that this long and very complex document has not really been given enough time for the public to understand and absorb. The other point I want to make is that we all need to be transitioning to multiple sources of energy. I don't think we want to eliminate fossil fuels as a source of energy. We need it. But we need to be transitioning to multiple sources of fossil fuels and making it so much easier for an industry which is somewhat environmentally problematic to expand is kind of like stocking your cupboard full of cookies when you're trying to reduce your sugar intake. We need to be diversifying our energy sources. Thank you.
Thank you, Ms. Campbell. Who'll be next?
Greetings, my name is Todd Schumann. I am a resident of Ventura County, but I am a property owner in Kern County. I own a house in Tehachapi. I pay taxes, to Kern County, just about $2,000 a year. So as a resident of Ventura County, I follow oil and gas issues in Ventura County as well, and I think some comparative perspective would be helpful. I also want to say that I'm a board member of a Ventura group called Citizens for Responsible Oil and Gas. And on behalf of, our acronym is CFROG, on behalf of CFROG, I want to recommend that we recommend that you pull back this proposal and reconsider it. We believe that any oil and gas permits should be under conditional use discretionary permits. That is the only responsible way to promote and encourage oil and gas drilling in a county. And so we're just going to kind of leave it at that. We have all sorts of issues with ministerial permits, and even though you're amending that, still it's a very short time frame. 7-day ministerial permit process is not sufficient to protect for the needs of the community. I want to bring up some issues concerning the greenhouse gas analysis. It's part of this is inferential because I actually was not able to find the environmental impact report on your site. I was not even able to find your environmental impact, the section concerning that, in the clerk's office of your of the Board of Supervisors up at the 5th floor. However, I was able to see some sections, and I want to highlight a couple things that I think are issues. I focus a lot on methane. It is good in this that you have a requirement that operators shall implement methods to recover and reuse or destroy methane. However, there's a big exemption there. Wildcat and delineation wells are exempted. Startup, shutdown, and maintenance system failures or emergency circumstances are exempted. Under those circumstances and those conditions, you can have pretty significant methane emissions released into the air. And methane is a very intense short-term climate pollutant that's 86 times more effective than carbon dioxide as a heat trapping agent. So this is something that you should be looking at more clearly, more deeply. The county is deferring basically to the state, the California Air Resources Board, and the San Joaquin Air Quality Control District concerning these matters. They use very low methane GW, global warming potentials to convert methane emissions into CO2 equivalency. They use a very long time frame, and it has the effect of underemphasizing the impact that methane emissions related to oil and gas have on the climate. So I encourage you to pull things back. CARB is actually in this process doing a short-lived climate pollutants evaluation, and they are now calculating methane emissions into CO2 equivalents using a 20-year interval, which is a much more responsible way of doing this. Also, we have a new state law, AB 1496, that recognizes the importance of using 20-year intervals in evaluating methane emissions. So for Kern County to be responsible on this issue, they should go beyond the minimum levels that are being set by the state and the San Joaquin Air Quality Control District and calculate methane emissions using reasonable intervals that actually correspond with the chemistry of methane. I have two documents I'm going to give to the county clerk for the record. One cites the relevant portion from AB 1496, which is now state law, and it also has a chunk account from the short-lived climate reduction policy strategy document of California Air Resources Control Board. And then I have another document that has information taken from the 2 relevant tables of the Intergovernment Panel Climate Change AR5 document that shows the importance of methane as a short-term heat-trapping agent, which I want to include them for the record. Who do I give them to?
Ms. Kraus will get them from you.
Thank you.
Thank you, Mr. Schuman. Who'll be next? By the way, we have lots of seats in the front row.
I'm Ara Martirosian from Sequoia Forest Keeper, and we've had 100 years of drilling in Kern County. We know that Dogger does not protect us. This ordinance will enable twice as many wells, and flaring from these wells will double the NOx emissions and possibly allow more methane to be released. Science indicates that NOx, methane, and other pollutants from the valley are killing trees in Sequoia National Park and the forests in the Sierra Nevada. Kern County must consider impacts to sequoias and other trees who do not vote. Thank you.
I'm sorry, could you give us your name again and spell your last name?
ARA is the first, the last is MARDEROSIAN.
Thank you very much.
Mr. Chairman, Larry Moxley, representing the Committee to Protect Ag Land and Groundwater. Although I didn't raise my hand, I wanted to come say hello. You've heard a lot of issues and concerns, and the people that I represent respect and think highly of the oil companies, their industry, their jobs, and what they mean to the economy. We are not against what you're considering. What we want is your full consideration. And I want to, for those of you who aren't Rotarians, I want to unilaterally make you honorary Rotarians and ask you to consider 2 points. In Rotary, we have a 4-way test. Is it beneficial to all concerned? Is it fair to everyone? And I want you to think about the distance from your seat to the back door, and think about having a house where you sit in an oil well at the back door. Is that fair to everybody? Does that seem beneficial? You have exceptional authority and police power, and legislating on the minimums is not what we need to do with something this complex and this impacting potentially to the environment. We have years of interactions and issues that we were hoping to solve with this process. And some of the concerns you've heard from my clients is we haven't gotten there yet. We don't think it's fair and beneficial to everybody if you have an idle well that's been idle for 40 years and you haven't given it back, and you haven't cleaned it up, and you haven't put the farmland back into production. We don't think it's fair to all concerned to put an oil well 210 feet from an ag worker's home or a farm owner's home or their domestic water source. We don't think it's fair that you're not required at least once to sit down and in a meaningful way meet and confer with the surface owner. This process doesn't do that. It helps a little, but it never requires a meeting of both the states. We don't think that's beneficial to all concerned. We don't think that's fair. I know each and every one of you. You're honorable people. I respect you, I hold you in high regard, and irrespective of your decision on this, I will feel the same way. And so I'm appealing to the people that I know well to be reasonable and give us the consideration that would truly be beneficial to all concerned. Thank you very much.
Thank you, Mr. Moxley. Is there anyone else here that would like to speak in opposition? I see someone here in the front row that hasn't spoken yet, I think. You must have wanted to go last.
How perceptive. My name is Ken Hunter. I represent Vaquero Energy. We are an oil and gas producer here in Kern County. We produce almost 100% of our oil in split mineral prime ag tier 2. I am here to oppose the voting in this meeting to certify the EIR and to vote to adopt the ordinance, primarily because I believe that there is opportunity still for the stakeholders in these amongst the agricultural community and the oil community to further if you will, negotiate. And as such, I would like a delay to allow that to occur. In particular, I am going to pass out to you what I think could be a start that could bring people together. But I need to give it to you now, so if you're bound determined to vote today, I would hope one of you would pick it up and make a motion to include it. But as I say, my great preference is that more time be allowed for ag stakeholders and at least our company, given the impacts on our operations, which are large because we operate 100% in ag land. Two most things that give me the most heartburn are this idea of surveillance. It kind of comes to me as obviously government, unnecessary, unreasoning government intrusion. If you want to take something away, call it "Don't Tread on Me." I mean, unless you have a good reason, of course. And I don't think this is a good reason. Secondly, it does bother me, particularly in the ordinance language, that there's really nothing about de minimis here, in particular about offsets for prime ag land. I don't think there's anything in there that says if you move a dirt clod, you know, the way I read it now, dirt clod for dirt clod. And I think that there should be some recognition of some de minimis amounts in the ordinance language. Anyway, I'll be here all day. If anybody wants to talk to me about that, online, offline, I'll be here. Thank you very much. Okay.
Mr. Hunter, did you say you had a document for us?
Ken Hunter, yes.
Sorry. Thank you. Are there any other people that would like to speak in opposition to the staff's recommendation? I'll wait for a moment if there's anyone in the rotunda that's making their way, trying to make their way in here. Okay, I don't see anyone coming. Well, perhaps I do. Perhaps not. Okay, we're going to take a break for lunch, and we'll come back and we'll have those who want to speak in support of the staff's recommendation. And we're going to take about an hour, so I would suggest, how's 1:30 sound to everyone? It's a little bit more. Thank you. Do I need a motion to adjourn? We don't need a motion. We're just taking a break. Thank you.
Love each other like sister and brother when we keep on falling back out of place. The cowboys and Indians could love each other like sister and